Wait, please, Your Lordship, my lord. Item 12, my lord. It's a contempt matter, my lord. In last order of that contempt matter, my lord, we were directed to file an affidavit on or before today. We have filed it just now, my lord. It is being filed. My lord, my twofold prayer, my lord. Either Lordship can take it up at 3 o'clock, so that in the meantime, the affidavit will be
3 o'clock.
my lord. Why I am requesting at 3 o'clock, my lord? Unfortunately, I am also a contestant in the election to be held tomorrow for the association. So today is the last day for campaigning, my lord. So I will be a little busy in the first half, my lord. If Lordship pleases, my lord. Otherwise,
No, we are interested on the compliance.
compliance is complied, my lord. We have filed the affidavit. We have filed the affidavit and it is complied with, my lord.
Affidavit has to be of compliance, that's all.
It's complied, my lord. It's
If you
complied.
see the last order, it has to be complied with. If
Yes, it is complied.
person has to come here.
It is complied, my lord. The lacking source is on our part that affidavit was not filed. But today it is affidavit is also filed. It is complied with. They will get their remuneration.
Let the affidavit be called, we'll see.
Well, that is why, my lord, affidavit be called, my lord, and if Lordship can take it up a little later, my lord, in the second half of the day, my lord.
We can have it at 2. To be precise.
My lord.
At 2.
No, it will come right now. The affidavit is not. The affidavit will not start to.
Yes.
That please, Your Lordship. Lordship, with the consent of the other side, I'd like to mention item number 14, Lordship.
Item 14.
Item 14. Mr. RPD, today some personal difficulties, Lordship, so may the matter be fixed up to 2 weeks.
Item 14, you say.
14, Lord.
I'm for the petitioner, my lord. The scenario is not well.
Who is not well?
Mr. RPD, Chaudhary,
R.K. Dev Chaudhary,
but he is. not
DSGI,
well. Yes,
DSGI.
He is here in court, but I is not well.
he's not keeping that. He is present.
Okay. But if you see the matters of the year 2014,
Lordship will fix a date, my lord.
It's a bit.
it doesn't look good that we adjourn like that. Okay, please write. It is submitted that Mr. R.K. Dev Chaudhary, learned DSGI, appearing for the Respondent Union of India, is not keeping well. And therefore, a prayer for adjournment has been made on his behalf. Stop. It is also seen that the case pertains to the year 2014. And therefore, let the matter be listed. Give a date. On 3rd September
Lordship.
2026, with an understanding that the parties will not pray for further adjournment. Yes.
May I please, your lordship? Item number 15, lordship, with consent to the other side, lordship. May kindly come up after 2 weeks, lordship.
Why? Nobody is interested to do MSCT case.
After long big matter has,
Huh?
lordship.
MSCT, what is MSCT? Is a claim made by a person
Yes, lordship.
because of injury, death, or something like that.
Yes, lordship.
This should be taken up on priority.
So, lordship, after 2 weeks, lordship, then.
Parties asking for compensation. Why do we adjourn like that? You're for the appellant.
Respondent, lordship.
Respondent. Respondent is who's respondent? Respondent, you are the claimant.
Yes, lordship.
You should be in a hurry. Why are you seeking adjournment?
After long wait, lordship, I have to go through the matter, lordship. So, lordship, after 2 weeks, lordship.
You can go through the matter during the course of the day. This is not the first item.
After 2 weeks, lordship, may kindly, lordship.
What is your good name?
Yeah, lordship.
Mr. A. Barua, learned counsel for the respondent / claimant, submits that since the matter has come up after a long time, he requires some time to prepare the matter. And therefore, he seeks for adjournment for 2 weeks. Stop. It is seen that the appeal is of the year 2016. And therefore, the parties should not seek further adjournment on the next date. Give a date. List again on 3rd September. Okay.
May it please your lordship, with the consent of the petitioner, lordship, I beg to mention item 27 of supplementary list. If in this matter, S. Sharma is appearing on behalf of the Health and Family Welfare Department, lordship, due to some medical emergency, she is not available. So, lordship, can this matter be taken up after a week, lordship, any date, lordship?
Have you informed the other side?
Yes, lordship, this for the.
Okay. What is his name? Standing counsel?
S. Sharma.
Miss,
Miss.
Miss S. Sharma, Standing Counsel Health Department is said to be not keeping well. And therefore, adjournment has been paid on her behalf. To stop the said prayer is not opposed to by Mr. R. Singha, learned counsel for the petitioners. Accordingly, the matter stands adjourned to be listed again.
On 20th, can it be 20th, your lordship?
I don't know. Any date can be given? Huh? So that's why you see the calendar and see the dates, on which date can we adjust. We don't pile up all the cases in one day like that. Just see what date can be given. Either in August or maybe in September.
Highly obliged.
7 September.
Can it be on 6th, your lordship? Let it be on a hearing day because it will be taken up for a disposal.
All right, 6 September.
Highly obliged.
Huh?
6 next.
Oh,
Eight.
sorry. Yes, 8 September. Sunday.
Lordship, I beg to mention item number 7. I am the petitioner. I want to file rejoinder. They have filed already affidavit in opposition.
Your lordship,
Item 7.
Date may be fixed, Lordship.
Hmm.
I have some objection here. Your lordship, if your lordship peruses 31/7/2026 order,
Hmm.
that the court had directed me to apprise this court regarding the implementation of the this stay order.
Hmm.
So that was implemented and a wrong submission was made on that day before the court. So I have brought those instructions. So your lordship may once go.
No wrong submission was made. Because
Totally misleading submission was made
No.
on 31/7.
You want to file rejoinder?
I want to prepare rejoinder.
Anyway, since there's some objection,
Hmm.
let the matter be called. We'll see. All right, we'll consider your submission.
Objection.
May it please your lordship,
Hmm.
with the consent of the other side, I beg to mention item number 19 and 20 of this today's list. Matter may be
Just a minute. 19 and 20.
I'm appearing on behalf of Mr. K.R. Patwari.
Uh-huh.
Due to some personal difficulties, he is unable to appear before this honorable court. So my lord may adjourn the matter for today and fix any date.
Was for the other side. Have you informed the other side? The conducting counsel for the petitioner, Mr. K.R. Patgiri, is said to have some personal difficulty to appear before the court today. On a prayer made on his behalf and not objected to by the other side, matter stands adjourned. To be listed again after 2 weeks.
A
Okay.
date may be fixed. My lord may fix a date.
We will get in September otherwise.
Okay.
Give a date, 15/9.
May I please check? Your consent of others said I beg to mention item number 17. I thought maybe adjourn for a week.
Item number?
17. 17.
Yes, what do you want?
Adjourn for a week.
Adjourn for
Week.
a week. You are appearing for
Respondent number 2.
respondent number 2. Who is that? Claimant? Huh? Owner? Why do you want adjournment?
It's not available.
Huh?
Some personal difficulties.
Why should we keep it adjourning like that? See, the matter of 2016. Who is for the appellant?
Insurance.
Hmm?
Insurance.
Counsel. Who is the counsel? Have you informed them?
Yes.
And what is your name?
You does.
Sorry?
You does.
AU.
You does.
You Das. You are the counsel for respondent number 2.
Yes.
Ms. U Das, learned counsel, appearing for respondent number 2, submits that she would like to prepare the matter and therefore prays for 2 weeks' time for the said purpose. Stop. She submits that she has taken the consent of the other side as well. In view of above, matter stands adjourned to be listed on 15 September.
Okay.
May I please, your lordship? I'm praying for a listing of a WPC, my lord, for motion. I'm praying because, my lord, there is some urgency. We have challenged the transfer order. I'm a government teacher, my lord. My daughter is suffering from cerebral palsy, my lord, a specified benchmark disability, my lord. And the transfer order was passed on 2 August. I received it on 5th August. I filed it yesterday, my lord. because I'm the primary caregiver of my daughter, and the now transferred place is more than 60 kilometers from where I'm posted right now, my lord.
But what is the underlying principles? Or what do you call, how one has to, like, act on that transfer? You are supposed to first join, then file a representation
I filed a representation, my lord. I filed a representation, no action
before joining.
before joining, my lord.
You have to join and file a
I
representation.
received the transfer order on 5th, my lord, on 5th August. On 6th itself, I filed the representation before the district elementary education officer, my lord.
No, there's a strict instruction. I've seen it somewhere
My
that you have to join, then you can submit your representation.
My lord, I have.
Then it'll be considered.
My lord, I have complied with that, my lord. I have complied with the representation that the procedure, my lord.
You have joined.
Yes, I have not joined, my lord.
Then
Well, I have taken leave, my lord. I have taken leave.
this is always the issue.
My lord, the problem is with my daughter, my lord. She is 12 years old and I'm the primary caregiver, my lord. And she is suffering from a benchmark disability, my lord. There are government regulations, my lord. The government regulations which prohibit transfer if the service holder is the primary caregiver of a disabled child, my lord. I have given documents, your lordship. And there are other grounds as well, my lord. I am the BLO, booth level officer. I was given election duty. On top of that, I have been appointed as the census enumerator of the present revenue circle, my lord. BLO plus census enumerator, plus my lord.
Okay, just a minute. Kim, how many cases are there tomorrow? It happened Monday.
Possible tomorrow.
Motion matters or together.
Possible tomorrow.
All right, tomorrow then.
I'm highly obliged, my lord.
Item 1.
Wait, please, Lordship. Matter is pertaining to Lordship, non-payment of compensation of family pension, Lordship. Lordship, I am the first wife of the deceased husband, Lordship. Lordship, as per Lordship, 143 of the Assam pension rules, Lordship, second wife is not entitled for any pensionary benefit, Lordship.
You are the second wife.
First wife, Lordship.
First wife. Now it is listed for referral for mediation.
Lordship, respondent authority say already sanctioned the compensation of family pension in favor of the private respondent number 8, Lordship.
Because we have a stay order with respect to that. 29/1/2026. The state.
Correct.
Because we have,
See, the reason it is listed today is whether it can be sent for referral for mediation or not.
it is not in mediation because we have given the family pension with respect to the documents that we have. In the death certificate, the name of the wife is Srimati Pushpanjali Sonowal, not the petitioner's name.
The second wife.
Second wife. Therefore, on the basis of the documents that we have given the sanction of the CFP. If your lordship wants to send it for mediation, we are okay with that.
Lordship, we are not interested to go for mediation, Lordship. Can you dispose the matter?
Because we have done it with records, that the kind of records we have. The sanction was given with the basis of our records.
No, it's
Instructions
not.
are there.
It's not your personal interest. It is the interest of your client,
Yes,
Mr. Counsel.
But
Please keep that in mind. It is not your personal interest. It is the interest of your client.
Yes, Lordship. Lordship,
What guarantee do you have that your client will get the relief?
Lordship, I am the first wife of the deceased husband.
Maybe, but you're not even the nominee. They go by the book. They go by the nomination made in the service book. So you should at least give an attempt. Straight away you say, I'm not interested.
Lordship, today.
That is not the way to put up a submission. Don't ever do that. That you're not
Sorry,
interested.
Lordship.
You may say that it may not be sent. There's a way of saying, you see.
I'm apology for it.
Otherwise, court also will say, I'm not interested to take up your case. You are for the second wife. Are you interested for mediation? You're interested. See, although everything is going to them, they said we want mediation.
Lordship, on coordinate bench also disposed on similar matter, whoever held that second wife is not entitled for any.
On the factual
The
basis,
learned counsel for the petitioner submits, Mr. What is your name?
Say Hati Moria, Lordship.
J. Hatu Moria submits that he is not interested to send the matter for mediation. Stop. The learned counsel is put to notice that it is not the interest of the counsel which is the primary consideration of this court for sending the matter to mediation. It is for the interest of the parties so that a settlement can be arrived at by the medium of mediation. Stop considering the submission made. Let the matter be listed for admission after 6 weeks.
Lordship, kindly fix a date, Lordship.
Registry will fix the date.
Okay.
Next. Yes,
So far I have discussed with my lordship, their interest lordship, they maybe send lordship.
sorry,
My client is interested to send.
You're interested.
Lordship, yes.
and for the employer, madam, the beneficial right might not let it be sent to mediation, which can be settled there.
okay. Parties are represented by the respective councils, then they submit that an attempt may be made for mediation. Accordingly, registry to send the matter to the mediation center immediately for urgent listing of the matter for mediation on priority basis
Lordship, interim order may be continuous, interim order is lordship.
by intimating the parties concerned. Stop. Meanwhile, the interim order passed earlier shall continue till the matter reaches back to this court.
Lordship.
Okay.
Stay clear.
Please, your lordship.
Mm,
Lord, this is a compassionate appointment matter, my lord.
mm.
Perhaps to be decided by this, prior to decided before this honorable court.
Compassionate matter.
Yes.
Mr.
So that it cannot be sent for mediation.
Okay, okay, the parties are represented by the respective councils and they submit that since the matter relates to claim for compassionate appointment, it may not be feasible for sending the matter to, for mediation. Accordingly, registry to list the matter for admission.
Otherwise, lordship can dispose of the matter I have gone for it. Honorable court has directed them to, if vacancy is available, then send it to the DLC, and DLC recommended her case, and it is not placed before the SLC. That can be the position in the objection of the petition. Lordship will direct the SLC to consider his case, if it is possible, and if it is not covered by the any office memorandum guidelines and code, then will pass a speaking order.
Okay, where is the SLC, DLC? Page 32.
Yes,
Yes.
Are you ready?
DLC,
Lord, they haven't filed any affidavit as on that.
or if you don't want to dispose of, then let it be file affidavit.
Sushmita.
Actually, my lord, there is another similar matter. Yesterday it came for listing, my lord.
Hmm.
Item number 27, same out of the same impugn order, my lord. So may I say, my lord, both the matters come up for admission, my lord, but day after. On Monday, my lord.
DLC, last before the DLC 15, 16, and 18 heist. Thereafter, he approached this honorable court.
Hmm.
Honorable court said,
Okay, we'll have it another day. We'll accordingly list the matter of the admission column. When? Give it
admission
on 14/9.
14 days.
All right.
Okay.
Orders item 13.
On this. My lord, last order, kindly peruse the last.
Just a minute. This is item number 13.
13.
Uh, So last time, Mr. B. Gogoi volunteered to assist the court.
Otherwise, the order against which the contempt application has been filed, that has been complied with, Malab. The Office of the Accountant General has already issued the PPO and the GPO, Malab. These are
Okay, let us see the order to be complied with.
My lord, page 20.
Page 20.
My lord, page 20. Para 8 of the. Para 8 from page 19.
They have to share it between 1 and 2.
Share and it has to be released, but my lord, not released. Till that I have not got it.
Who is going to release that?
Treasury Officer. These
Tre-
are the pension payment orders and the gratuity.
Treasury officer is a party here.
No
No,
problem.
my lord.
So, Mr. Chaliha, can you help us?
No, Lordship, I have the instruction, Lordship. I was, Lordship, on the last date, we are appearing for respondent number 4, we are assisting the court. Lordship, the petitioners have not visited the treasury officer. They have to go and sign and give them their details, which the petitioners have not done. That is what
No, they have visited.
you have called, you have been in touch. But the petitioners have to go in person and give their bank account details. That is what, all the documents, the contemners in the petition, Lordship, they have complied with the orders and they have forwarded all the necessary documents. Now the treasury officer is waiting for the petitioners to come because they have to verify, they have to submit certain documents, they'll need their signatures. That has not been done, because of which it has not been released.
Okay, treasury officer of which place?
Dhubri, Lordship.
Dhubri.
They are aware, Lordship. They have not been made a party, but they are aware.
But my lord, as per my instruction,
Uh,
the treasury officer works for 2 or 3 days in a week because he is some other inserts also. The petitioners visited thrice, my lord. Even
Lordship
Friday
may-
also they have been asked. So my lord, it may be next week in the Friday.
Lordship may fix
petitioner
a
has
date
been
when the
asked.
petitioner can come, the treasury officer will be there. Let my learned friend give a date as per his.
Friday, as per my instruction, they have called the petitioners.
Lordship,
Friday.
now. any
They have
date-
called on
Called.
Friday. This Friday, tomorrow.
This Friday.
That is tomorrow.
Tomorrow. So
Yes.
let it
So you
next
go-
week.
Yes, Lordship, they come, they'll sign, they'll get the necessary. I have not
Uh-huh.
even submitted the bank account details over there.
No, they have earlier, they have 2-3 times they have went to the office, but the officer is not available because he is sometime works for in Bilashipara, sometime work in a week, my lord.
Okay,
Works for
so
2
take a date. You said you have been called on Friday, you go.
Let my learned friend give me a
Okay.
date when the.
Mr. B. Sharma and Learned Counsel and Mr. A. Chaliha,
For respondent number 4, I'm assisting the court. Because respondent
Hey,
number 4
Chaliha.
was
Learned
arrested.
Standing Counsel, Finance Department. Both
well as
submit
they
that
have-
the orders of this court has already been complied with since the PPO has been issued, and also the PPO and GPO has been issued. And it is now pending release by the treasury officer. Stop, since the treasury officer, since the petitioner has not approached the treasury officer of
Dhubri, Lordship.
Dhubri, for the requisites. The amount perhaps has not been released, could not be released. Mr. M.R. Khandakar, Learned Counsel submits that the petition has been called by the treasury officer on Friday. On date, give the date. on 14/8/2026. Considering this, considering the submission, let the matter be listed again on so and so. 26/8.
I'm deeply.
29 of the complaint is for ours.
May I please, Lordship? Instruction received, Lordship. For 3 weeks time will be required, Lordship.
20.
For filing a petition.
29. Lordship, I.
Yes,
May-
29. What is it for?
Lordship, I have filed an IA, Lordship, for amending the address of the respondent number 4 and 5, Your Lordship. So I may be allowed to take a fresh steps upon respondent 4 and 5.
4 and 5.
Yes.
What is the subject matter?
Your Lordship, the petitioner was removed from the service, Your Lordship, and the unauthorized absent period was considered as a dice non, Your Lordship.
Okay. And who are 4 and 5?
For respondent number 4 is, Your Lordship, the former inquiry officer, and number 5 was the present inquiry officer, Your Lordship.
You want to implead them by name?
Yes, Your Lordship, by name.
Why do you want to implead them by name? You're alleging malafide
No.
or what? They were already impleted, isn't it?
Yes, Your Lordship, but
But
they have been transferred.
Because of the transfer, you could
Yes.
not. Where are they situated now?
One is in Kamrup district, Your Lordship.
Yes,
It's an
please.
additional.
Mr. Chakraborty?
Lordship. Sir, I am appealing for respondent 1, 2, and 3, Lordship. Lordship, I have received the instructions, Lordship. File a affidavit in opposition.
How much time you require?
3 weeks, Lordship.
Okay. What about the IA?
I have not received an IL.
Why you didn't serve a copy? Did have served a copy?
Your Lordship.
Hmm. This is served, this is filed by way of undertaking. Do you have an extra copy?
Yes, Your Lordship, I can give it.
They want to amend the address. Miss
L Wangsai.
L Wangsa. Wangsa,
Yes, Your Lordship.
learned counsel for the applicant to submit that by filing this application, the applicant seeks to amend the address of the respondent numbers 4 and 5. Since notice could not be effected to them in the old address. Stop. The learned counsel submits that if the prayer for amending the address is allowed, the petitioner would be in a position to take steps upon the said respondents. Stop. Mr. A. Chakraborty, learned State Counsel, appearing for the respondent numbers 1, 2, and 3. Submits that he has no objection to the prayer. In view of above, the application stands allowed as straightforward. IA stands disposed. Next para, in view of the order passed today in IAC number 2763 of 2026, petitioner to file the amended cost title in 2 sets before the registry within 3 days, 3 working days. Stop. The petitioner should also take steps for service of notice upon the respondent numbers 4 and 5 in the new address within a week. Stop. Mr. A. Chakraborty, learned State Counsel, submits that the appearing for respondent numbers 1, 2, and 3, submits that he has received the Paravas comments and he may be granted how much? 3 weeks time
3 weeks.
to file the counter affidavit. Prayer allowed. List the matter again after 3 weeks.
Obliged.
Okay.
Petition item 4.
Read please, Your Lordship.
petitioner side, we have that Himanta Sankadev Kalakshetra, my lord. The petitioners are brought under a regular scale of pay and other instances on, my lord. 20 June 2018, my lord. My lord, there is a LICI group insurance scheme, my lord. But it similarly situated 16 numbers of persons has already included in that scheme, my lord. But the petitioners are deprived from this scheme, my lord. My lord, they file an affidavit, my lord.
Is it available in the record now? 11:8. Okay.
It should start from page number 53.
'53. By 2 and 4, isn't it?
Yes.
Respondent number 2 and 4. Okay. How many respondents are there?
There are 4 of them.
Six responded, my lord.
There were some. Is SCRM. Not 3, it's 4 only. 3 is Director of National Affairs. And 4 is the Secretary of Motor.
4 respondents.
4.
My lord, 6 responded. I filed from. My lord. Financing LIC.
Okay, it was amended later on.
My lord.
Secretary, Assam Culture Affairs, Vice Chairman, Srimanta Shankar Deva. Cultural Affairs Director, then Finance Secretary, then Life Insurance Company, LIC also. 2 and 4. Two and 4 has filed. Who else has filed?
My lord.
Who else have filed?
2 and 15, my lord.
2 and 15? There are only 6 respondents.
Yes, my lord.
Respondent number 1 has filed. 2 and 4 has filed. Then who else?
I think he shall be covered by respondent number 1.
4 has filed again separately, singly aligned, has filed separately. Okay, what is the matter about?
Our standing is there.
No, not your stand. What is the matter about?
Matter relates to, my lord, to LIC group is insurance scheme, my lord. My lord, they have stated at para 4, my lord, page 54, my lord.
Directing the respondents to include the petitioners in the LICI group insurance scheme, which has been formulated by department. To other similar situated employees of Srimata Shankar Deva Kalakshetra Society for the purpose of getting retirement benefits. You want to be included under the LIC group insurance?
My lord.
That is your prayer.
My lord. They
Is-
already.
Yes or no? You want to be included in the LIC?
My lord.
That is your prayer, isn't it?
My lord.
You are the employees of?
Sankadev Kalakshetra, my lord.
Okay. So are the employees covered by the LIC or not?
My lord, covered, my lord. There are similar situated person, 16 numbers of person already, my lord.
Where?
My lord,
Where is it?
NHRB, my lord.
Page?
Page, my lord, 29. 29 to 31, my lord.
29 to 31. 29, there are 10 people. 31, there are 5 people. 15. And 32 is another one.
Oh.
16 of them.
16, my lord.
What is the post that you're holding?
Different post, my lord.
Like,
Three post lordship.
grade 3 post. And you are appearing for?
Supporter Polaka.
Okay. What is your stand?
Our stand is that we have already discussed the matter with the LICI and when that determined benefit, heavy investment we are giving. And for gratuity also the decision has been taken. It is clearly written in page 4 and
Page 54, my lord.
page 54. May I read that?
Just a minute. You have to wait for the court to see the page also. Why are you in a hurry? Page 54. Yes, this is your affidavit by 2 and 4.
Page 54, my lord.
Yes, I'm in page 54. Which paragraph?
4.
Please read.
That the deponent begs to state that the office of the deponent had discussed the matter of the petitioner's claim in its executive council meeting that 11/3/26 made a detailed discussion in the matter. The executive council meeting advised to introduce the gratuity scheme beginning from April 2026. The meeting, it was discussed that the Srimantos Supporter Polaka Society forwarded a proposal to the government of Assam for grant of leave encashment, gratuity and pension to the petitioners by creating new head of account 21/7, but no response was received from the end of the government till date. Under such circumstances, the respondent society discussed the matter with the LICI. And after discussion, the respondent was asked to pay rupees 6,45,000 as the first installment dues during the financial year 26/27. Out of the total amount of rupees 41,15,365 for payment of gratuity, the petitioner will from June 2018. It was agreed by the LICI that the respondent society shall pay the remaining amount in 5 equal installments. The meeting, it was confirmed that the society shall already introduce the leave investment benefit scheme covering all regular employees including the petitioner in the present case. So they're given the leave and discount.
Just one thing, just a minute.
Yes.
Just a minute. Executive Council decided to give the gratuity scheme from April 26. This is one. Then
Therefore, it was forwarded to the government.
the society forwarded proposal to the government, but there was no reply.
No reply. Therefore, it was not done.
Then now
Discussion with the LIC.
the society has discussed with LIC. And the respondent was asked to pay. Respondent means which respondent?
We are.
Okay, the society was asked to pay
Society was asked.
6,45,000 as first installment. This will cover how many people? How many employees? All
All the petitioner.
petitioners.
Yes.
Petitioner.
You have other employees also.
No, that decision is with regard to those employees. only.
Okay, how many petitioners are here? 28.
28, my lord.
LIC matter was discussed LIC and the respondent was asked to pay 6,45,000 as first installment for the financial year 26/27 out of the total amount of
41,59,360.
for payment of gratuity to petitioners with effect from June 2018. LIC, the respondent shall pay the remaining amount in 5 equal installments.
My lord.
That means 41,59,365 divided by 5.
Yes.
The meeting confirmed that the society had already introduced leave encashment benefits covering all regular employees, including the replacement.
Should be covered by first installment 6,48,000 and the remaining, that is 45 lakhs and all that will be covered by 5 equal installments.
First deposit will be 6,45,000,
The remaining.
remaining in 5 installments.
Yes.
So
My lord.
matter can be closed, I think.
My lord.
Only thing is that they have the claim of pension also. They are not at that level. Whereas society is employers. The decision is taken to give the leave replacement and the gratuity.
Okay, just a minute, huh? Where do we have the gist of the case? Have you provided synopsis anywhere?
My lord.
Okay, please write down. Heard, Mr.
N. Borua.
M. Borua, learned counsel for the petitioners,
R. Sharma,
and Mr. R. Sharma, learned counsel for respondent numbers
2 and 4.
2 and 4. And who else? And Miss S. Borua, learned state counsel for respondent numbers 1 and 3. That's all?
Well, 5 and 6 not appeared. So,
No, no. Huh?
LSI was the respondent, newly impeded. They are appeared.
Notice has gone to them.
Finance ready.
Please write. Having regard to the nature of grievance projected by the petitioners and the developments that have happened after the filing of the writ petition, the writ petition is taken up for disposal. Stop. Next para. 28 petitioners have joined hands to file the instant writ petition. Stop. According to them, they are working as temporary employees under the Srimanta Sankar Deva Kalakshetra Society. And they were brought under regular scale of pay, White Office order dated 26/2018. Stop. Apart from regular scale of pay, the allowances admissible under the state government and under this admissible to the employees of the state government have also been extended to them. Stop. It is the case of the petitioners that (16) similar situated employees of the society. So earlier I had given that Srimanta Shankar Deva Society, no? Bracket you put society. According to the petitioners, 16 similarly situated employees of the society have been included in the life insurance have been made to be covered under the Life Insurance Corporation of India Group Insurance Scheme formulated by the Cultural Affairs Department, whereby the employees enjoy retirement benefits such as pension, gratuity, and leave encashment. Stop. Despite having been brought under the regular scale of pay, the petitioners not being included under the said scheme. Have approached this court through the instant writ petition. Stop. The respondent number 2 and 4 bracket society have filed their affidavit in opposition on 30/7/2026, wherein they have stated that the government was approached for introduction of the gratuity scheme from April 2026, but no response has been received. Stop. Therefore, the society had a discussion with the LICI authorities for extension of the gratuity to the petitioners. And after such discussion, it was agreed that the society would deposit the required fund with the LICI which is to the tune of rupees 41, 59, 365. Stop. It was further agreed upon that the society would initially deposit rupees 645,000 and the remaining balance amount in 5 equal installments. Stop. It is further the contention of the respondent numbers 2 and 4 that it was confirmed in the said meeting that the society has already introduced the leave encashment benefit scheme covering all regular employees, which would include the petitioners as well. We'll stop. Paragraph number 4 of the said affidavit opposition is abstracted hereunder for ready perusal. Page 54 and 55. A to A. Mr. I forgot your name.
N. Borla.
No, LIC.
R. Sharma.
Mr. R. Sharma, learned counsel for the society, submits that since the petitioners are not government employees, what did you say about the pension?
They are employee of the society.
Since the petitioners are the employees of the society, they would not be entitled to monthly pension as claimed by them, except for the gratuity and the leave encashment benefits, as already stated in the affidavit. The learned counsel for the petitioner, Mr. So-and-so,
N. Borla.
N. Barwa, submits that since the meeting with the LICI has been successful as stated in the affidavit, the grievance of the petitioner has been met, and therefore, insofar as the pension is concerned, the petitioners would not press for the same. Can I record that?
Aunt has been, my lord.
Pension? Can you claim for pension
My lord.
from society?
My lord.
Can you claim? Under what provision?
My lord, fund has been, my lord, supplied by cultural affairs, government of Assam Cultural Affairs Department. So that-
He, however, submits that the said issue may be kept open. Hmm? Hmm. Yes, what did you say? In your affidavit?
Our stand is that Lordship, in page 44, paragraph 4, Lordship.
Hmm.
May I read, Lordship?
Hmm.
That with regard to the statement made in paragraph 4, 5, 7, 8, and 13 of the writ petition, the deponent states that as Srimanta Sankardev Kalakshetra is a society, employees drawn salary from granting aid, so except for granting the amount, other service matters do not come under the purview of the Cultural Affairs Department. Service matters have to be decided by Srimanta Sankardev Kalakshetra Society. The
No,
Cultural
no,
Affairs
just a minute. Affidavit filed by respondent number 4,
1,
page.
44.
No, my 44 is different. Just a minute. It has been repaginated. Paragraph 4.
Yes, Lordship.
It's page 51 in my copy. So anyway, read.
That with regard to the statement
Hmm.
made in paragraph 4, 5, 7, 8, and 13 of the writ petition, the deponent states that as Srimanta Sankardev Kalakshetra is a society, employees drawn salary from granting aid, so except for granting the amount, other service matters do not come under the purview of the Cultural Affairs Department. Service matters have to be decided by Srimanta Sankardev Kalakshetra Society. The Cultural Affairs Department had consulted Finance Department on the matter twice, and extract of the views of the finance department are enclosed herewith for reference as Annexer 1. In Annexer 1, but something different is now. Annex, kindly see the Annexer 1. It is the view of finance department also.
But the proposal regarding gratuity also you did not respond to. That's why they had to go to the LICI. LICI has agreed. You deposit this amount, we'll see that the gratuity is given to them.
The whole.
So now the ball, you're setting the ball back to the society, and society is saying that we cannot give pension. Matter ends there only. What can
Yes,
be?
service.
Huh?
Cultural department, they have been not decide the service methods.
That's what we are saying.
Some monetary balance, that matter every year, anyway. From that, they will have to manage and they can give pension or anything, but from their own resources. They cannot now start the burden upon the state executive. Take the people. They are employing, they will have. Because we generate for the previous by the revenue, their revenue sources.
So we are closing the matter.
My,
What did I say last? Hmm. Well, you however submit that cut that, okay? Next para, considering the above developments. The read petition stands closed. Mr. One, in the beginning part, right? You are a respondent, the finance department.
Respondent number 5.
Uh, Mr. B. Gogoi. Learned additional easy appears for the respondent number
5.
5. Ms. Barua is also there.
1 and 3.
Oh, your name's already recorded.
Yes.
Uh-huh. Okay, so we have closed it.
My lord.
Next.
Okay.
This lordship,
Hmm.
matters of pertaining to some matter regarding demotion. The respondents filed an affidavit in opposition on the last occasion. So we seek some time, lordship, to file a reply.
How much time?
Lordship, 3 weeks.
There is wait for 3 weeks time is granted to the petitioner to file affidavit in reply. List again after 3 weeks.
Made reservation. Your lordship, I am appearing for the respondents. And your lordship may kindly peruse the order dated 31/7/2026.
Yes, I've read it.
So there was a order directing me to apprise the court regarding the instructions. So this is the instructions.
No, you have said that on the next date, the learned counsel for the respondent shall apprise the court as to how the interim direction
Yes,
passed by this court has been implemented.
yes.
What is
So
the interim order?
the interim order was not to proceed with the notice dated 31/2026 of discontinuing the petitioner in his service.
What is that interim order date? Passed
Interim
on?
order is 19/5/2026.
19/5.
Petitioner was allowing to resume his duties.
The impugn discontinuations of notice shall not be given effect to,
Yes.
and the petitioner shall be permitted to render his service on the existing terms and conditions allowance. What is this? Discontinuance of notice means?
Your lordship will find the notices at page 15. 15 and 16 of that petition.
What is the petitioner?
The petitioner is a watchman in the respondent company.
Watchman.
Yes.
Respondent company is
Is WAPCOS.
Huh?
WAPCOS.
What is the full form? WAPCOS?
Water and Power Consultancy Services.
Okay, watchman on
Yes.
contract basis.
Yes, on a contract basis. So
Then by this notice,
by this notice, this contract, he was discontinued in service with effect from 28/2/2026. As per the
accordingly,
cons-
upon completion of the notice period, your contractual engagement with so-and-so shall stand discontinued with effect from so-and-so, strictly in accordance with the terms and conditions of your contractual appointment. So he has challenged this.
So he has challenged this.
Hmm.
So on 19/5, the court had stayed this to notice. So thereafter, when the matter was listed on 31/7,
Hmm.
31/7, the counsel for the petitioner had informed the court that this interim interim order was not acted upon.
Hmm.
However, as per the instructions, immediately we have acted upon the interim order. The
Hmm.
interim order was passed on 19/5, and we allowed the petitioner to join his services on 21/5/2026. Lordship will find in the instruction which I have submitted just now.
Where is that?
Second page, your lordship will find the joining letter, 21/5/26. Joining report of the petitioner to us.
Yes.
Thereafter, the attendance registered from me.
Okay, what do you want to show? Yes, join back, interim
Yes,
order.
so we just want to show that we have acted upon the interim order.
Okay.
And thereafter, your lordship will find that we have filed the this affidavit also, and we have cleared our stand.
Okay, he wants to file a rejoinder, that's
Yes,
all.
yes.
We allow him to file what is there.
Yes. Only a short date may be fixed because the terms of agreement is up to 39/2026.
Your good name, please.
As the
Mr. S. Datta, Learned Counsel, appearing for the respondent number.
1 to 5.
For the respondents, all of them.
Yeah, all.
Appearing for the respondents submits that the interim order passed by this court on 19/5/2026 has been complied with. In this connection, he submits that the petitioner had submitted his joining report on 21/5/2026, and he has been allowed to resume his work. To support his submission, he has submitted the joining report of the petitioner as well as the attendance register maintained in this regard. So, Mr.
B.
Fugan, Learned Counsel for the petitioner, submits that he has received a copy of the affidavit of position and would like to file a reply affidavit, and for which he prays for
1
a week's time. Praise aloud. List again. 27/8.
27. Obliged.
Obliged.
Here we are yet to file an affidavit. If the third time it has come up, I pray for some further time to file an affidavit. Recent case, my lord, okay, it was issued in May month.
How much time do you want?
Further 3 weeks time.
Okay, let's pray for by Mr. B. Govind on additional age. Further 3 weeks time is granted to the respondents to file the counter affidavit. List again on 11/9.
Well, same issue, same.
Similar order.
Item 10.
Here, Lordship, some instruction received, Lordship. So far, Lordship, regarding the birth certificate of the petitioner, Lordship, and during the verification, Lordship, it appears that it is a fact document, Lordship. Therefore, it is sent for investigation, proper verification through the department, Lordship. That is the present position, Lordship.
When did you send it?
Yeah. Lordship.
When did you send?
Yes, that
for
was in February, Lordship. But so far,
You have not received the reply till now.
yes, Lordship, still now we are not received a reply. This is my up-to-date instruction, Lordship. Good question. I said, doubtful. সেইকাৰণে এটা এনকোয়াৰি বহাইছে আৰু অকল তেওঁৰে নহয় কেইবাজনো আছে Lordship, the Paraguay's comment which is sent to me from the office of the state level police recruitment board, Lordship, I submitted, Lordship. In that
Just a minute, Mr. Goswami. Okay, this Paraguay's comments you've given
Lordship.
regarding February, he said he was asked to appear on 25th February.
Yes, Lordship, kindly see, Lordship, kindly see the last, it is last paragraphs of this, of the Paraguay's comment. It is categorically stated on 08/06/2026. The Director Tree Tribes and Adivasi Welfare Assam was requested to furnish the latest status report regarding the cancellation of the caste certificate of the petitioner by this office letter dated so and so dated 08/06/2026 forwarded by remaining reminder email on 16/06/2026 in response to the Director Tree Tribes and Adivasi Welfare Assam Rupnagar Gauhati by so and so dated 10/06/2026 forwarded the said letter to the chairman state level caste scrutiny committee, social justice and empower department, Dispur. However, the final status report is still awaited, Lordship.
Chairman, state level caste scrutiny committee.
Yes,
They are not a party here.
yes, Lordship. They are the
Are they a
social-
party?
No, social justice is not the party here. The social justice department.
This is the government inter-government departmental communication.
Hmm.
Well, things to be viewed like this. After due scrutiny, everything found to be correct, genuine, and he was selected. And thereafter he was asked to collect the appointment letter. Can you see a page 41? After completing the whole process of recruitment, this ultimately was issued to him at page 41, annex 6. This shows application number so and so, candidate's name, Krishna Sohan. Congratulations, you have been selected for the post of constable, AB, so and so. Date of distribution in due course, intimated in due course. This was on 11/10/2025. Left hand column date is there. And then Lordship will see Annexure 8, notice was issued that we should come and collect the appointment letter at page 44. Meanwhile, they issued this notice as Annexure 7, 42, that selected candidates should come and collect. Name, roll number have been made known, published there. And then this notice, it is hereby informed of, second part I am reading at page 44. It is hereby informed that the candidate selected under 3% quota of 3 tribes and Adivasi communities with one guardian are requested to attend the appointment letter distribution ceremony at Janata Bhavan, Dispur, Gauhati on 8/12/2025. I came. Others were given, I was not given. So I went to office letter also several times. They said something is going ahead. Wait. Ultimately, I had to come. Well, the thing should be considered like this. They have found me the selected candidates, they eligible from all point of view, and they are to give me the appointment letter. If tomorrow, even if I joined, they find something against me, they can always conduct an inquiry and take action against me if I have given something wrong information, some wrong information to you. But how can they hold it back? Because others have already been allowed to join. They have joined. and I'm lagging behind now. Otherwise, I have a right to be appointed and to earn my livelihood. But these are backward classes. This certificate was issued by the authorities themselves. Now, as has been coming from the government side, that if somebody has raised certain question mark, that has to be viewed and looked into. Conducted, this might take some time. But how long I should wait? This was on 8/12/2025. Thereafter, we are in now August 2026. Distribution ceremony was concluded on 8/12/2025. And we are in August 2026. Therefore, my absolute submission is, if there is something, they may go ahead. Court will not restrict them, but let them issue the appointment letter. Let him earn his livelihood. His family is looking up to him. For these almost 8 months, the whole family is suffering, the person is suffering. There is no point denying the appointment to him because he is already selected. Therefore, I will pray that Lordship will direct them to appoint me, give me the appointment letter, and then if any inquiry they want to make, it is free for them to go ahead with it. Nobody stops them to do that. It is always with them.
No, Lordship, with a fake document, Lordship, he cannot appoint.
Who can say that
Yes,
it is
it
fake
a-
document?
Now under inquiry, Lordship. We are waiting for that confirmation from that department, Lordship.
So no
We are-
confirmation.
No, we are waiting. And
Waiting how long?
no,
Question is
it-
this ballot
no.
question to
We are waiting.
say that this is a fake document. There is no
Lordship,
substance on it. There has to be some
Lordship,
basis.
let
for
me submit my affidavit in opposition with the present status of this case, Lordship, and call for a report from the Social Justice Department also.
Nobody prevented them from doing so for last 2-3 months. When was this petition moved? It was on April 2026 filed and thereafter immediately notice was issued. And now we are in August. Not that no opportunity was given to them. But things are not moving in the direction it ought to have moved. This is the concern.
So you file the affidavit, we'll grant it some time,
Yes, Lordship.
but you file it within 1 week.
Yes, Lordship, I will file.
Well, it was expected of. They are
No,
not coming forth
Mm.
with.
I will
Please.
submit my affidavit within a week, Lordship.
Let them do if
Yes,
they
sir.
want. But my question is, it was their document who is saying that yes, you are found genuine, selected. Therefore, if somebody has raised certain
After
question,
verification, it appears.
that means they didn't do verification.
He's right.
The
Okay.
document verification.
Heard Mr. K.K. Manta, Learned Senior Counsel, assisted by Miss M. Kakoti for the petitioner, who submits that despite the petitioner having been selected to the post of constable under this is what at CIPF recruitment or what?
Yes, sir.
Or
State
Assam
level
Police?
Police Recruitment Board, Lordship. This is the state level boards.
What did I say? Despite? State level
Police Recruitment Board.
police recruitment board. And informed to collect his appointment letter. White communication dated. No, white notice dated 29, notice dated, white notice dated 29/11/2025 and 6/12/2025. He has not been given the appointment order. For reasons best known to the respondents. Top Dilanet, senior counsel submits that the petitioner was selected against the 3% quota meant for T tribes and Adivasi communities. Mr. J.K. Goswami, Lanet State Council, submits that the, what do you call it, caste certificate?
Yes, Lordship, plus.
The caste certificate of the petitioner is under cloud. And therefore, the Director, T Tribes and Adivasi Welfare, Assam, was requested to furnish latest status report regarding the cancellation of caste status of the petitioner. Stop. The director in turn has written to the chairman, State Level Caste Scrutiny Committee, Social Justice and Empowerment Department. And the final status report is still awaited. Okay, next para. Although notice was issued on 15/5/2026, the respondents have not filed their counter affidavit till date. Having regard to the submissions made by the grabbing parties, the state respondents are required to file an affidavit to bring on record what exactly had transpired. In other words, the reason as to why the petitioner has not been given the appointment order despite being selected. The affidavit shall also state what steps have been taken by the respondent authorities concerned as regards the doubt expressed about the caste certificate of the petitioner with supporting documents. Such affidavit be filed on or before. Mr. Goswami, when will you file? I'll give you a date.
Next week, Lordship.
And you must file it.
Yes, next week, Lordship, Friday.
See, we have given this parawise comments. This may not be sufficient. You have to get precise information.
Yes.
The sequence, how it has.
During this period, I will bring the status, present status from the concerned department. Friday next.
List the matter on 25/8. Huh?
25.
Okay, 25/8
Lordship.
on Tuesday.
Possible.
Interim will continue. Interim
What-
order will continue.
What interim?
Interim not to fill up the post.
Is it like that?
Yes.
Is there any interim order? Let me see.
Post.
Okay, interim order passed earlier shall continue till the next date of listing.
Till disposal, Lordship will say,
No, it's a next date, Lordship.
Next date, we'll see.
Next date.
because otherwise also they cannot fill it up immediately against me because I am already selected against that. Therefore, if they come up early, court can dispose it up early.
They will come, we have to be indicated.
All right.
May I please the Lordship? Lordship, I have received parawise comment. I'm going to file an appeal.
When?
Lordship, 3 weeks time.
A little shorter, my lord, I have been terminated. But it is a unique case, my lord, where the appellate authority has become the disciplinary authority. They have called for witnesses who are part of the criminal proceedings. No,
The shortage of manpower, I think.
Lord, they excessive. That's why, Lord. They have done it twice.
Mr. J. Hendik, learned counsel appearing for the respondent number
1 and 2, Lordship.
1 and 2 submits that he has received the parawise comments and prays for 3 weeks' time to file the counter affidavit. So Mr. R. Dubey, learned counsel for the petitioner, on the other hand, submits that the petition has been illegally terminated from service and prays for a shorter date. Accordingly, are you filing any affidavit? So let them have 3 weeks, considering the issue involved. 3 weeks' time is granted as paid for. List again also, and so. Please write one more line, Mr. K.C. Sutia, learned senior counsel and senior government advocate, appears for respondent numbers 3 and 4, and also prays for 3 weeks' time to file counter affidavit. Praise aloud.
Deeply held.
26 of the supplements.
Let's will kindly peruse the last order. Print up.
I think it should be TC. That's a AC, it should TC.
He has shared some instructions. See, yes. Direction was of this court was when except West Bengal, if is there any vacancy to accommodate me in Assam?
The petitioner has been your rate as per your rank.
Well, that's-
Assistant Sub Inspector Malati Devi.
Yes.
Yes, any instruction?
Just now I have received one instruction
Hmm.
from the. Just now I have.
You have read it? You have not read it also? Then-
There is no vacancy is here. Two and six. Except vacancies in West Bengal, Dukapur.
That means you have read your instructions.
I also just had a glance, my lord. So they say no vacancy anyway, except West Bengal.
So what is to be done then?
But that document, if I just had a chance to look at it only for a moment, this premises are something different, my lord. They say that promotion, that post all is available there, my lord. Otherwise, my lord, in my affidavit reply, I've already stated that no, in this group central, there are two serving ladies, my lord, in the same post.
Yes, Mr. Datta, what do you make of it, this instruction?
It is the for Mahila CFA personnel, it is not available. The vacancy is not available here except at Dugapur. And he also ready to go. But this owner will make out person order directing the authority to post the petitioner, to transfer the petitioner to such a place where the medical facilities are available. Well, if here, in additional affidavit, he has stated that I have settled the matter. I engage a person to look after my mother. Undertaking, my lord, that is a page my lord 119, my lord.
Anyway, I'll come back in 5 minutes. In
Additional affidavit.
the meantime, just analyze what is to be done.
For that, I want to bring the notice of this honorable court, the bold letter, the letter received today, my lord, at para 2B, my lord. Bold.
Yeah, see,
The post of ASI, GD, Dugapur is not, Mohila is not authorized in other field unit deployed in area near to Dugapur, West Bengal. The service in other static location by namely group centers, range office, sector office is not counted as mandatory field service for next range promotion. What is mandatory field service, my lord, stated in our standing order. Standing order at page 95. Page 95 of edition, affidavit in opposition. It is the standing order 4 of 2022 at B, my lord, at page 97, 11, please. Transfer on promotion. My lord, got it, my lord.
97.
97,
Oh.
11, please. B, my lord. Transfer on promotion, repartition, newly appointee, etc. On promotion. One A, my lord. On promotion. Officers, personnel in whose case MFS mandatory, that is the MFS is the mandatory field service. MFS. Is required for next promotion as per RR's recruitment rules may at first instance be posted to a unit establishment where duty is counted as field service. On promotion, officials personnel posted in field unit may also be considered for retention till completion of their normal tenure subject to availability of vacancies. It is. And now, my lord, she has completed more than 7 years here against 3 years tenure. And here, my lord, in additional affidavit, my lord, 117. She applied for voluntary return. And they have to recall we have accepted it. But they have submitted a representation, my lord.
application at page 112, my lord. This is the application for voluntary retirement.
So currently, where is the petitioner? Gauhati.
My lords, that I have countered, my lord, in my affidavit reply at page 129.
See, now we required instructions regarding whether it's possible or not.
Yes.
Apparently, it says that it's not possible.
No, my lords, what happened? I have a few clients from this force. One of the one client which I have not filed the petition, my lord, there's the one lady. She has been brought into Guwahati and then been transferred to RAF Rapid Action Force in Nalbari. It's the same post, my lords, the ASI. So that very instruction which says that the post of ASI is not authorized, it's completely misleading, my lords. It's completely misleading. If lordship, I can produce that also.
RAF.
Rapid Action Force of the CRPF, where there is, my lords, a post of ASI, my lords. And even in this, if we go by this instruction simpliciter, it will go to, it reveals that there's no, ASI is not available anywhere. This bold letters is trying to
But the
insist
fact
upon, my lords.
remains that you have also accepted the posting.
Yes, my lords. No,
You have
I'm
accepted the posting.
ready to forego also, my lords. I'm ready to forego, give away everything.
Forgo what?
My promotions, my lord. If they are insisting me to promote me and send me to West Bengal, in the light of these, that standing order, provisions of the statutes which I had, my lord, tried to
But you have already
demonstrate.
accepted the promotion. That's the problem. Last time we had already observed that.
And my lords, at page 129, my lord, if we read this instruction in my lords, in a different manner, my lords, it indicates, purportedly it indicates that there is no provision for ASI Mahila anywhere. Which is totally misleading, my lords. At page 129 of my additional affidavit, reply affidavit, my lords, I have demonstrated, well, two posts are there, my lords. There is provision for two posts. The two persons serving there.
See, primarily, I'll tell you, the best person, the best authority to know where you are to be posted is the respondent authority.
Understand, my lords.
See, court cannot substitute its view that this will be better. It's better you go there, or instead of this, you go there. We cannot do that.
But that I fully understand, my lords. But my lords,
the instruction otherwise perhaps it's not in your favor.
well, instructions.
So only option now is to hear the matter and dispose it of. As well.
Yes. Lordship will then hear it next Tuesday, my lords. Lordship will dispose it of. That can be indicated in the order itself, my lords. I know he's under pressure because I've been enjoying a stay for last 1 year.
Was it position Tuesday?
Why?
Or next Thursday. 28.
What is the situation in 28? No, not on 28. Maybe before that. 20, even 220. Oh, we can have on 20.
20 minutes.
Oh. Mr. A.K. Dattal on CGC submits that as per the instructions received by him, there is no scope for transferring the petitioner in nearby places apart from the place of transfer in Durgapur, West Bengal. As agreed to by the parties, list the matter on 28/2026 for admission hearing.
Ma'ams. All right.
Please, your lordship. Prayer for adjournment, my lord. The English council got an accident, my lord. The English council, H.R. Ahmed.
Is it serious?
Yes, my lord.
Is serious?
Yes, my lord.
Serious?
Yes, my lord.
What happened?
The English council got an accident, my lord. Small accident.
Is the accident serious? What happened?
No, my lord, it's small accident.
Small accident.
The matter may be 2 weeks, my lord. Fixed.
Yes, what you saying, Devi? Is Devi?
Lordship, his candidature was rejected due to his dental point for
No, regarding the prayer for adjournment.
adjournment, Lordship. Yes,
You
Lordship.
object to the adjournment? No. Okay. It is submitted by Mr.
A. Malik.
A. Malik that The conducting counsel, Mohammed H.R. Ahmed, has met with a minor accident. And therefore, we praise that the matter be adjourned for 2 weeks. Ms. A. Devi, London CGC, has no objection to the prayer. In view of above, matter stands adjourned to be listed again after 2 weeks.
My lordship. I'm appearing on restaurant number 1, madam. I have some difficulties today, madam. Your lordship accommodate me any date, madam, except today, madam.
What difficulty? You are here?
No, I have not prepared, madam. Fairness, I think. I am not prepared, madam.
You're the claimant, isn't it?
I'm the claimant.
What is there not to prepare?
Actually, my lord,
On what ground you're challenging?
actually, my lord, this is was not, death is not of injury, my lord. He was, his death was on septicemia.
But the question is, madam,
Injury, not from injury. He was death of, disease was on septicemia, my lord.
Then did you file WS
Yes, my lord.
before the tribunal?
In tribunal, my lord.
You filed WS.
my-
And what did
and
the trial
deposit-
court say? What did the tribunal say?
My lord, in deposition by doctor, my lord.
See, simple thing which you have just said is that he did not die of accident, but of septicemia.
Yes, my lord.
That was your stand in your WS written statement before the tribunal.
Yes, my lord.
What is the finding of the tribunal?
Finding was, my lord, actually, he was admitted in hospital about 1 month only, my lord. Thereafter, he was discharged, my lord.
Okay.
And after 8 months, my lord, he was again admitted to the hospital, my lord. And there was nothing connection with injury and ailment, my lord.
Okay. During his admission for 1 month,
Yes,
what was he suffering from?
injury, my lord.
What injury was that?
Injury on her buttock and limb, my lord.
Okay.
And limb, my lord, only.
So that injury could be the cause of septicemia also.
Yes, my lord.
Maybe it happened later on.
Yes, my lord.
Anyway, that is a dispute.
Yes,
But
my
how do we settle such kind of dispute in a
And also,
proceeding like of this nature?
and also, my lord, he was not wearing a helmet at the time of accident, my lord. This
Who are
is-
the witnesses examined? Whom did
no
you
eye,
examine?
no eyewitnesses there, my lord.
Forget about eyewitness.
No,
Any witness examined?
Yes, my lord.
Who?
His wife, PW1.
No, relating to the injury.
Independent witness is there, my lord. Self-help group, I think, my lord.
Wife did not see the accident.
They have not seen, but vehicle was parked on self-help group society, my lord.
Okay, how much is the award?
About 19 lakh, my lord.
19.
19.
19
Any
lakh.
amount withdrawn?
50%
50% you have already withdrawn.
They have already withdrawn.
So kindly got them.
I have some, I'm not prepared.
Let some time may be given, my lord.
Any date, my lord.
You are also not prepared.
No, my lord. I am prepared, my
You are
lord.
prepared.
But I have no citation.
Whether that injury part is, madam, septicemia is, madam, relating to that injury, madam. That is it.
Not injury, my lord.
Whether septicemia is due to cause of the, madam,
No medical
injury?
document. is,
The claim was under
submitted.
166
Yes, my lord.
on fault basis. So what is the evidence that you led to show that
Madam, doctor has said, madam, that
septicemia
it is,
was
septicemia is
due to the accident?
Madam, doctor said that, madam, septicemia is due to the, maybe,
No
maybe
document proof is given, my lord, by them.
maybe, madam, that incident, madam. That incident, madam, septicemia is due to
Bed sore, my lord.
Doctor was examined.
Examined.
Yes, my lord.
That's all examined.
In page number 131 to 134, my lord. He declared there, my lord. In tribunal record, my lord. LCR.
So they have withdrawn 50%, so that's why they're not in a hurry.
That's why, my lord.
Huh? When do you want it?
Any that my lordship condition.
But this is a matter of 2016.
Well, any day.
That doesn't look good.
But even his condition, her condition is not also well, my lord. She may die any moment. My lord.
Mr. A. Khainegar, learned counsel for the respondent claimant submits that he needs some more time to prepare the matter. What is the matter stands at not? You list it again. It's at
Deep level.
Wait, please, your lordship. Kindly, lordship, kindly pass over the matter for timing as the senior is not available.
He's not available.
As he is engaged.
What
with
happened?
other
You cannot
matters.
trace him. Where is he gone? Huh? Missing person. Oh. He's on legs or something. Where is he?
I think he is in trial court.
Oh, he's in trial court.
Let it be after some time.
After
You know, how does the court react when it is informed that the counsel is going to trial court? Do you know? But I'll not give that reaction. You have it some other day. It'll take time, I think.
I think not, my lord, because they were supposed to produce that record only.
No, I'm saying that person who's gone to the trial court will take time.
Lordship takes up at who, my lord? Just Bhutan.
There is other matters, 6, but 2. What is this service matter?
Yes,
Of course, service matter.
Non-consideration of the promotion of the petitioner, my lord, since 2012 to 16, my lord.
In which
He
post?
has already retired for the post of divisional manager in the LIC, my lord.
LIC. So after retirement, you are still the cause of action.
No, the petition was filed during his service, my lord.
Correct, but
Meanwhile, he retired.
now any benefit you will get.
My lord, I'm praying for a notional benefit.
The notional benefit. If you succeed, that promotion will be there, and
Yes.
from that day onwards, there'll be some
In fact,
benefit.
my lord, the record will reveal
Hmm.
that the LIC, my lord, in every year when the promotion were done, those people who were about to retire, my lord, their fixation was done on that grade. But however, the petitioner, my lord, in respect of the petitioner, he was never given a consideration, my lord. Although he was within the zone of consideration. His batchmates, his juniors, everyone was promoted, my lord. In fact, on the last occasion when this matter was heard by this honorable court, my lord, this honorable court wanted to see that promotional committee's record to ascertain, my lord, whether any consideration was given to him or
Record. Was there any order for records?
my lord.
I don't see any order like that.
My lord, Justice Goswami's order.
There was a date of the order. You have a date. Conducting counsel for the petitioner is said to have some personal difficulty. Although Mr. B. Kaushik, learned counsel. No, I'm sorry, conducting counsel for the respondent. Huh? Respondent. LIC. Is said to have some personal difficulty, although Mr. B. Kaushik, learned counsel for the petitioner is present. As paid for, list the matter.
15.
Next.
That please the lordship. My lord, this is a case where the petitioner is challenging the finding of inquiry. Now, the petitioner was originally an employee of the state of Arunachal Pradesh and posted as CDPO. Now, she was on deputation to FCI. Now, during her deputation, certain allegations were leveled against her, and before the inquiry commenced, she was repatriated to her parents' department. Now, after her repatriation to the parents' department, FCI, who was the borrowing department, conducted the inquiry. She wanted to get the inquiry done by her parent department. She raised certain issues. She submitted application for certain documents.
What is the parent department?
State of Arunachal Pradesh. From Arunachal Pradesh, she went to deputation to FCI.
As what?
While serving in Arunachal, she was serving as CDPO. And on her deputation to FCI, she joined there as area manager, FCI. Now, while serving at FCI, certain allegations were leveled against her. She was placed under suspension and a charge sheet was issued. After the issuance of the charge sheet, she was repatriated to her parents' department. After her repatriation to the parent department, FCI commenced the inquiry by appointing a presenting officer and then inquiry officer. Initially, she wanted time. On the first day she participated, she wanted some records to be handed over to her by the inquiry officer, but nothing was done. She prayed for certain times, but it was not allowed, and the inquiry went ex parte against her. The inquiry officer.
Ex parte inquiry.
Ex parte inquiry.
By the FCI.
FCI. Inquiry officer submitted his report to FCI authorities. FCI then forwarded the report to the parent department for penalty. Because under the rules, since she was on deputation and she could not have been penalized by FCI. Now we are challenging the inquiry at that stage, and there is a stay order operating and no penalty has not yet been inflicted. Basically, we are challenging the inquiry on 3 points.
Stay order passed on which date?
Lordship, that date I do not remember. The motion says not to take any coercive action.
On the first date.
On the first date. And it was extended and ultimately it was allowed to continue till the final disposal.
The stay order is of date 24/5/2009.
On the day of when the matter was moved. So, may I take your lordships to the facts, my lord?
Just a minute.
Huh? Huh?
What is this board which is mentioned here? What board?
My lord?
Board.
Board?
Yes.
Where, my lord?
Petitioner has contended that the aforesaid course of action taken by the FCI authorities without obtaining necessary approval from the board is illegal. Which board? It is in the order of that 24/5/19.
Board means FCI board, perhaps, my lord. Board of directors. But basically, my lord, the issue is here whether FCI could have conducted the inquiry after a repatriation. Number one. Number two, whether the report of the inquiry officer can stand the scrutiny of law.
Is it not possible in law?
Yes.
That you are on deputation and.
No, My lord,
The-
if I am on
The borrowing department has conducted inquiry. Is there any bar?
borrowing department can conduct the inquiry.
Uh,
So long I am in the borrowing department. Now, after my repatriation, the master servant relationships goes.
Where's the law on that? And you have any authority?
Yes, my lord. It is on, I've given the list of judgments, my lord. Perhaps that has not come. Now, in a similar case, in an armed forces case, where a person was in Indian police, went to BSF on deputation. Now, in the BSF, certain inquiry, after his repatriation from BSF to the parent department, allegations of certain irregularities in BSF, he was repatriated to the police force. Now, when the inquiry commenced, he took up a plea that since the offense took place at BSF, so I am guided by the BSF Act. In that context, Supreme Court said, no, you could have been guided by the BSF Act so long you were in BSF. But once you have come back to your police force, you will not be guided by the BSF Act.
So that is regarding the provision.
Yes. So the
whether
question,
BSF Act or whether Police Act.
Yes.
But here is a question, whether you can still be proceeded with by the FCI, although you have been repatriated back.
Because, my lord, my humble submission is, if I am an employee of state of Arunachal Pradesh, I am on deputation to FCI. Now, so long I am on deputation, I am continuing there under FCI, I will be guided by the FCI rules and regulations. Once I am repatriated to my parent department, my relationship of master and servant with FCI comes to an end. So the FCI regulation will not be applicable to me. Similar in the case of BSF.
That is why they send the finding to the
the
government of Arunachal Pradesh to give you the penalty.
So the very conducting the inquiry was conducted under the FCI rules.
So that is why at the outset, if you can show me that provision, I think the matter will be in a very short compass.
My lord. Lordship, if you're
without opening many of the pages here, if you can show at the outset that the very conducting of inquiry by the FCI, although you have been repatriated back in the government of Arunachal Pradesh, is illegal and not permissible, matter ends. Show me anything.
Now, if for that, I'll be relying on that Supreme Court decision. I'll be reading certain paragraphs because the Supreme Court says once repatriation takes place, the borrowing department cannot exercise or the...
Yes, you allow me to read that by giving me that citation.
I've given the list of books, but perhaps it has not come.
List of books.
2003, 11 SCC 508.
Please read slowly. What does it say? Relevant.
Paragraph 8. This section describes the person who was subject to BSF Act. Subsection 2 of this section makes it very clear that the person once subject to that act shall remain so subject until he retires, discharged, released, removed, or dismissed from the force in accordance with the provisions of the Act and the rules. Thus, it is to be noted here that as per this section, once the appellant ceases to serve BSF in accordance with the provisions of the Act and the rules, he ceases to be a person subject to that Act. In the instant case, the appellant was deployed to serve the BSF while he was discharging Indian police service on his deputation to his parent department. He ceases to be an officer with BSF. Therefore, by virtue of Section 2 of BSF Act, the appellant ceases to be a person subject to the BSF Act from the date of his repatriation. So, my lord, the Supreme Court is saying, Honorable Supreme Court is saying that if you are a subject of the BSF Act, you will be subject to the BSF Act till you are in BSF. Once you are in repatriated, so you no longer remain a subject of the BSF Act. Here, my lord, if we apply this analogy, I, being a deputationist, I am a subject of FCI so long I am a subject, I am in FCI.
Okay, what is the disciplinary rules applicable to FCI? And to
The
that-
FCI,
And,
they have,
and secondly, to that of the government of Arunachal Pradesh,
Arunachal Pradesh follows the CCS rules,
CCA rules,
CCL rule,
central
rule.
And-
FCI have their own regulation.
regulation.
Yes, that is guided and it is applicable to all FCI employees.
You have been proceeded against the said regulation.
Yes, I have been proceeded under the FCI regulation. It is one aspect of the case. Another aspect, my lord, if your lordship takes up the inquiry report, that inquiry report, it is an ex parte inquiry. What happens? The allegations are that I committed so and so committed, and because of this huge crores of rupees loss was caused to FCI. Now, in the inquiry, all reports are relied upon, investigation reports, CAG reports. These are the reports. My lord, first of all, these reports are not evidence in support of the allegations. These are findings of certain, it can at best be a fact-finding substance which can form the basis of initiation of the proceeding. Now, what happens in the inquiry? The inquiry officer records, these are the charges, these are the documents exhibited, this is the presenting officer's argument, and last, no reason is assigned. Lordship may have a look. I'll take your lordship to the findings of the inquiry. If your lordship takes up the inquiry.
So both sides are ready.
My lord?
You're ready.
My lord, I'm ready.
You're ready for hearing. You're also ready?
Also ready.
FCI.
FCI.
Any other party involved?
Yes, madam. Government of it. Government.
Arunachal Pradesh.
Arunachal Pradesh.
Proforma.
No,
No, ma'am.
because she was our employee.
Huh?
The petitioner was our employee, so she was on leave.
Correct. But have you filed affidavit?
Yes, we have fine.
What is your stand?
We have supported.
You have supported. Penalty is not imposed till now.
No.
There's an interim order, that's why.
In fact, my lord, government of Arunachal Pradesh has given a go ahead to with the inquiry, my lord. That is page number 107, my lord, of the affidavit in opposition of the government of Arunachal Pradesh.
No, what are you saying?
Petitioner was allowed to participate by the government of Arunachal Pradesh to participate in the said inquiry.
But despite that, it's ex parte.
She was participating, but she chooses not to participate, my lord, because she was in each date of hearing, she was giving a plea that I am busy on this, I am busy on that, today I am not well.
Okay. So we'll go step by step.
My lord.
So rather, I will say that it was not ex parte, petitioner chooses not to participate.
So, lordship may come to
No, before that,
facts, how and in what.
what is required, you see. What is your appointment?
Yes.
CDPO.
CDPO. Paragraph 1.
Oh, there's no document.
This is a statement and it is an admitted position. She was appointed to the post of CDPO in the year 1991 as a direct recruitee under the Arunachal Pradesh Civil Service.
What is the time, date?
Date of appointment, my lord, in the year 1991. But the date is not.
Direct appointee.
Direct appointee. Then at paragraph 3, the petitioner was borrowed to FCI on 10/6/2011 for 2 years.
10/6/2011.
For a period of 2 years, which was extended from time to time, and she continued at FCI up to 21/9/2016.
Up to
21/9/2016. She was released from her parent department on 2/9/2011.
That means about 5 years, more than 5 years.
Yes, initially it was for 2 years. It went on extension up to 21/9/2016. She was released from her parent department on 2/9/2011 to join there. And petitioner joined FCI and was posted as Area General Manager, Bandardawa on 30/9/2011.
But you were talking about 10-6-11. What is 10-6-11?
My lord. 10-6-11 is the order where she was allowed to go on deputation. This is, the petitioner was borrowed by FCI. 10-6 is the order by which she was allowed to go on deputation, and she joined, released on 2/9/2011.
No, 10-6-11 is the appointment order, I think. Appointment order.
Appointment order.
Okay.
Now, Lordship may come to paragraph 9. May I read, my lord? The petitioner discharged her duties honestly and sincerely to the satisfaction of all concerned. Her performance was not spotted by any stigma. All affairs of FCI under her control were duly audited by internal auditor as well as the external auditor from the office of the CAG for the year 2012, 13, 14, and 15, where no irregularity with regard to the performance of the petitioner was pointed out. In the year 2015, same group of auditors from the office of CAG audited the affairs of the office of the area manager Bandediwa. They submitted their audit report wherein they pointed out some irregularities for the period 2012, 13, 14, which were not mentioned in the earlier reporting. Now, that report pointed out certain irregularities, and then based on the audit report, she was she was transferred from Bandediwa to Itanagar office, and then she was transferred to Gauhati and placed under suspension. Lordship will have a look at the order by which she was placed under suspension. She was placed under suspension on 24/5/2016, page 31. Whereas disciplinary proceeding against so-and-so, so she is placed under suspension. The then area manager posted under regional office of Arunachal, who was joined FCI from the Department of Child, Women and Child Development Department, Government of Arunachal Pradesh since 30/9/2011, are contemplated for causing huge loss to the corporation. So-and-so. It is further ordered that during the period this order shall remain in force. The headquarters of so-and-so, the then area manager Bandediwa, will be Zonal Office, Gauhati.
Where is the repatriation order?
My lord.
Repatriation.
Page 54. (29/2016). In pursuance of FCI headquarter office order number so-and-so dated 12/9/16 issued from file number so-and-so is hereby relieved from her duties with effect from 21/9/16 to join back her parent cadre so-and-so. Then, my lord.
Just a minute. With effect from
21/9/2016. Order dated 29/16 and she was released with effect from 21/9/16.
Prior to this, you were already suspended, correct?
Yes.
24/5.
24/5.
So it continued.
Yes.
It is not that you had already gone back and from there it started.
No. They suspended me. They issued a charge sheet. And then repatriated me.
Where's the charge sheet?
Yes. The charge sheet is 19/8/2016.
Page?
Page number 33. Now, my lord, when the inquiry officer and presenting officers were appointed, Lordship will have a look at page 55 and 56. The inquiry officer was appointed on 24th of November 2016.
No, before that, let us see the charge. What is the
Yes.
charge?
Charge.
Article 1 is missing trucks.
Missing trucks. Now, Article 1, missing trucks. Episode of 41 missing trucks loaded with so-and-so from Sensua district Noga for unloading at Tawang and Sepa during the month December 13 and 14 through so-and-so, so-and-so. So, I was posted at Bandardeva. The truck went from Assam to Sepa and Tawang, and the truck did not reach there. I was charged for a misconduct.
You were posted at that time as what?
Bandardeva.
As
Area manager. Now, charge number 2.
so during your entire tenure in the FCI, you were area manager.
Area manager.
No other designation.
No other designation.
Area
Area
manager.
Initially at Bandardeva, then I was, once the irregularities were alleged, I was posted to regional office at Itanagar, and from the day I was placed under suspension, I was brought here at Gauhati.
What is your jurisdiction as area manager Bandardeva?
To look after certain depots. This Tawang and Sepa comes under my
It covers Arunachal also.
Entire Arunachal Pradesh.
Entire Arunachal.
Entire Arunachal.
No.
Only one district office was there, divisional office at Bandardeva. It covers all of the Arunachal Pradesh then.
And Bandardeva is in
Bandardeva is the divisional office. Where for all the transactions taken place now. So Arunachal Pradesh have only one divisional office, that is at Bandardeva. So she was in charge of entire Arunachal Pradesh.
Okay. Entire.
Entire.
So you have only one area manager.
Only one area manager.
I see. And what is the hierarchical, what the other posts?
Above divisional office, there is a regional office where general manager,
After area manager, you have divisional.
Area manager is presiding over the district office. Above that is a regional office where regional office is at Itanagar, where we have general manager post, DGM post, and AGM post and manager level.
I see. And below the area manager.
The head of the head of that district office at Bandardeva.
Below
area manager.
Below area manager, what do you have?
Manager, then AG3 post, AG1 post, AG2.
So missing trucks. Number 2.
Number 2, irregular payment. Fraudulent payment of handling bill to contractor SD Enterprise by DO Division Office Bandardeva, causing collateral loss to FCI to the tune of 84.78 crores. Then third, excess payment to the tune of so-and-so made to the contractor on account of excess distance. And fraudulent payment to contractor on allowing to join at a later date. So
4 charges.
4 charges. Now, my lord, interestingly, my lord, the similar charges were alleged against other people also. All are level of that Bandardeva office. All are level that you are committed this.
Anybody has been penalized?
My lord?
Anybody else has been penalized?
Someone penalized, challenged, then order of penalty set aside, inquiry set aside, everything.
Okay.
One Mayur Datta's case is there. I'll refer to that case later on, my lord. Now,
Charge.
charge.
Then you were required to show cause?
Show cause, I requested for certain documents which were not given to me.
This memo of charge itself is a show cause. Oh,
Yeah, no, this is the charge sheet. This is the article of charges. This is a memorandum of charges. This is the article of charges, statement of imputations.
Where's the show cause?
This is the charge sheet given, no show cause, no prior show cause. This is what they are relying. This is the charges.
No, it straight away started with memo of charges.
Yes. It's straightway.
What about your written statement of defense?
My lord, I wanted to certain documents which were not given to me.
No. Was there any such kind of direction to you to submit your written statement? of
Yes,
defense? Where's that
At the end of the
page?
page 33. This is the first one. She is informed that an inquiry will be held. So and so the area manager Bandadua is further informed that if she does not submit her written statement of defense on or before the date specified in para 2 above, or does not appear in person before the inquiring authority, otherwise fails or refuses to comply with provisions of regulation 58 of FCI regulation 71 or of the orders direction issued in pursuance of the said regulation, the inquiry authority may hold the inquiry ex parte against her.
Okay.
So
10 days, 10 days. You have
So
to submit within 10 days.
yes, I prayed for certain documents which was not given to me.
When did you pray for that documents? By which letter?
Page 79.
Page 70.
70.
92,000.
70 is the affidavit or what?
No, page 70 of the writ petition.
This was 9817, correct?
9870.
9817.
Malad.
But then 10 days was given to you on 14 August 2016. How do you go to 2017 now? What happened between missing link? This was document was requisition, I mean, this demanded by you to for the purpose of
Now,
hearing.
what happened, my lord?
Hearing which was scheduled for 25th of
Yes.
July 2017.
Because 19/8/2016, the charge memo was issued. On the next month, that is on 29/2016, I was repatriated to my parent department.
Maybe, but within 10 days, did you submit your statement or not?
No.
You did not submit?
Not submitted.
Okay.
It was not submitted, but the fact remains that after issuance of the charge sheet on 19/8/2016, she was repatriated to her parent department on 29/2016. And thereafter, the inquiry officer and the presenting officer were appointed. Page 55, inquiry officer was appointed on 24/11/2016.
55.
24/11.
Page 55.
Page 55. Now, that order is very clear. An inquiry, whereas an inquiry under regulation 58, the disciplinary proceeding under the FCI regulation. Now, the charge sheet under FCI regulation, regulation 58 of FCI staff regulation 71 is being held against so-and-so, the then area manager, Bandar Dua, now repatriated to Department of Women and Child Development Department, State of Arunachal Pradesh, right? So-and-so. So, charge sheet under FCI regulation, inquiry officer appointed under FCI regulation, presenting officer appointed under the FCI regulation.
Okay, we're dealing with FCI. So we need to have some food also.
My lord.
Come back at 2.
Mal.
With regard to indulgence, lordship indulgence, item number 23, hearing. It's taken up some other day long.
So this is what you were discussing all the time.
No, my lord. Because I am tied up in some other 2012 matters.
After seeing Mr. Chakraborty arguing, they say that this will take time. So let us have some other day.
No, my lord. In court 7 also I am tied up with a 2012 matter, my lord.
Item 23.
23, my lord.
When do you want it?
Any date, my lord. Next week, any date.
Next week, I don't know, it may not be possible.
Yes.
We'll have a date in September.
Lordship.
My lord, that attempt 24.
17 9.
My lord, item 24 also.
Oh, it will.
Just a minute.
17 9.
17. As paid for by the parties. Matter stands adjourned to be listed on 17th of September 2026 for hearing. Item 23, isn't it?
Yes.
Then
24.
24. This also you want adjournment?
Yes.
Who's for the other side?
Lordship, I am appearing for the other side, Lordship.
Any objection?
No objection, Lordship. It has come after 2 years, Lordship. I also need to go through the entire these things, Lordship.
Okay, similar order, but date, same date, okay.
Lordship,
Similar order.
17 9. Deeply obliged, Lordship.
I hear. Continue. Let's complete that. There's one small order matter.
Mal.
Complete that. The affidavit is here.
You know, the affidavit that we have filed, you know, perhaps it has reached, you know.
Yes. There's no document next to the affidavit.
Well, the affidavit, only the one page inquiry report, you know, that I'm just providing to your lordship, a copy of this. This has gone to make the photocopy. And we have complied, so far as the judgment of this court is concerned, Milord.
What was the direction?
The direction is at, Milord, page 8 of the contempt petition, Milord. From second paragraph, if I may read, Milord.
It's okay. To pay wages, salary of the petition for the period mentioned above. If they are found to be, there's more than one of them.
Yeah. Milord, we have found, Milord, that they are entitled to. The inquiry report has come. I'm just providing the copy to your lordship. May keep that copy, marking it as an X.
Why did it take so long?
Milord, so far as ASTC is concerned, Milord, it's a dying organization. And Milord, very frequently, Milord, MDs are being changed. Why don't we keep a copy of this inquiry report, Milord? Following which we have decided, this inquiry report says, Milord, that they are entitled to the remuneration.
No, why was it not annexed to this affidavit?
Milord, this has reached me little late when I filed. It was not in my hand, so I just got it some few minutes ago. So lordship, we keep it on record, giving a mark, Milord.
How many petitioners are there?
Only 3, Milord. Sorry, 3, Milord. 3. Milord, what we have sincerely prayed, Milord, that they should file an application in the sincere division, and upon that application, we'll be paying within 2 months. Milord.
The lower portion is not visible.
Pardon?
Last line is not visible. Conclusion.
Well, let me take the original one. Photo stated. So. Oh, it is being.
The relevant appointment, attendance, payment, and official correspondence record supporting the unit has been verified and are enclosed herewith. This is a verification report by
the General Manager HR, similar.
on which date? When did you visit?
24/6/2020 at the top. Date is at the top. Right hand corner.
No, this may be the date of submission of his report because the signature is also 24/6. When did he go to the Silchar? That is not known.
My lord, when did he go, Lord? I have the order of the managing director directing him to proceed for inquiry. That is on 18th of June 2026.
Madam, you are there in this case?
Lordship, I am on behalf of my senior MH.
Hmm?
I am on behalf of my senior MH Laskar.
Where is he, Mr. Laskar?
It is a medical emergency he has to leave to.
Do you know anything about this case? It's your duty to assist the court. See, you all have impleaded one Mr. What's his name?
Anand Prakash Tiwari.
No. The second one.
The Chinmay Prakash Pukan.
Chinmay Prakash Pukan has been impleaded.
He has not been impleaded.
No, Mr. Just listen to me.
Well,
There's an IA. He has been impleaded. They have been directed to file the amended cost title. They have not done so. IA was disposed of. Where's the IA? IA was disposed of on 8/4/26. 8 April 26, and you have not replaced the cost title also. Despite that, CK Pukan has filed the affidavit.
well, we have mentioned it.
You have not been vigilant also. See. That is one thing. The other thing is that the order dates back to the year 2018. What is your explanation of not complying with the court's direction since then? 8 years have passed.
Well, at that point of, particularly on that point, I have to take instructions.
8 years have passed. You take instructions, we're not closing the content.
Well, may I get back this original or?
Definitely, I'll give it back to you.
I may be allowed to file a comprehensive affidavit.
What is your name?
Lordship S. Ahmed.
Yes, Miss S. Ahmed, learned counsel appears on behalf of Mr. M.H. Laskar, the engaged counsel for the petitioners. This contempt petition is filed alleging willful and deliberate violation of the court's order dated 3/9/2018, passed in WPC number 5961 of 2018. Stop. Court had directed the respondent authorities concerned, particularly the managing director STC, to pay the wages oblique salary of the petitioners for the period mentioned in the order after proper verification. And in the event they have been found to have worked during the period claimed for. Stop. The exercise was to be completed within a period of 1 month from the date of receipt of the order. Stop. We are in the year 2026 now, and the order is yet to be complied with. Stop. Further, the right respondent number 1 has already been replaced by another incumbent, namely Mr.
Chinmay Prakash Pukan.
Chinmoy Prakash Pukan. Stop. The petitioner sought implement of the present incumbent by filing IAC number 679 of 2026. And the same was allowed by order dated 8/4/2026. Stop. The petitioner was directed to file an amended cost title within 2 weeks from the date of the said order. Stop. The same has not been done. The petitioner shall therefore file the amended cost title within 3 working days in 2 sets before the registry of this court. Next para. Mr. A. Chabot, no, Mr.
HMO.
A. Chamor, learned counsel, submits that although the present incumbent managing director has not been informed about his implement from the senior manager bracket legal of the STC has filed an affidavit today stating that an inquiry was conducted by the general manager HRA STC by visiting the office of the ASTC Silchar division. Upon visiting, it was found that the petitioners were engaged as trainee assistant and had rendered services during the period mentioned in the report. Stop. He has also collected the relevant appointment, attendance, payment and official correspondence records supporting their engagements. Stop. The same were also verified and have been enclosed to the report on factual verification dated 24/6/2026. by the said general manager. Stop to support his submission. The learned counsel has produced a copy of the report of factual verification dated 24/6/2026. Stop. Since the report is not annexed to the affidavit filed today, the respondent number 2.
Sole respondent, I believe. Yes.
Who will file? Mr. Samo?
My lord.
Mayuri Kalita will file again.
Yes, yes, fine. She is
The,
authorized.
the senior manager legal shall file an additional affidavit incorporating the verification report while mentioning the steps being taken in furtherance of the verification report. Such affidavit be filed within
2 weeks, because we have to bring everything on.
2 weeks.
In the meantime, my lord, if they file an application, we may be allowed to pay them, my lord, to comply, find full compliance of the honorable court's.
What application?
My lord, what we sincerely pray before this court, my lord, if they file an application, because one thing we do not have in our file, that is the appropriate appointment letter given by the.
No. See, the report which you have just produced has said the relevant appointment, attendance, payment, official correspondence records supporting engagement have been verified and are enclosed herewith. So this officer, general manager, has collected all those documents.
All right.
So I
We
think
may be allowed to pay them, my lord, for
You
compliance
process.
of the. So that the order can be fully complied with.
Right. List the matter again. No, before that, we'll list it. See. We have given you how many days for your thing, submission of the cost title? A minute.
3 days.
3 days. Let it come up next week. Give a date. After 3 days.
Well, on 21, it may be difficult for me to file an affidavit.
On 19. No, I've given you 2 weeks time.
My lord.
19, we are listing
My lord.
so that we issue notice to the second
Yes,
respondent.
Second respondent, right.
They have failed to take steps.
My lord.
We have to regularize that.
That is correct.
List again on 19th of August. Miss, you understand what we have said, correct? That cost title amended, you have to file. Within 3 days, you file. We will take it up again on 19th. Then we have to issue notice to the second respondent. Take back this.
My lord, may we pay them if they, if.
Yes. Of course, the respondents, the respondent authority concerned is not debarred. If respondent authority concerned shall do the needful. In the meantime, in paying the dues of the petitioners, considering the report that has been submitted by the general manager.
HR.
General manager or what?
Yes. Our general manager, HRA.
HRA.
IC.
HRA.
I don't know. It is
What is
written-
HRA? My lord, human resource is there.
Human
HR.
resource and admin.
Oh, admin, that's right. House rent allowance is also HR.
HR, human resource and admin, we didn't make it IC.
Okay.
I'm obliged.
My lord, may take two relevant dates, my lord. Lordship has already seen that the charge sheet was issued on 19/8/2016. And on 19/8/2016, the suspension of the petitioner was revoked, my lord.
On which date?
On the day the charge sheet was issued, on 19/8/2016, charge sheet was issued. And on 19/8/16 itself, the suspension order was revoked.
Any order to that effect?
My lord, it is an admitted position. We made a statement in the writ petition, which is not denied by them. Suspension order revoked, my lord. It is an admitted position. To that effect, a statement is made in the writ petition, my
But
lord.
there has to be an order also to revoke. Verbally they revoked or what?
No, there is an order, but that order could not be annexed in the writ petition. However, my lord, the reference of that order finds mention in a letter which your lordship may look at page number 69. Now,
Have you made a statement otherwise in the writ petition?
Yes, and the reference of that order is there in page number 69, annexure T. Now, this is a letter to CMD FCI by the petitioner after issuance of the charge sheet seeking certain documents. It is not, my lord, that it is first time in the year 2017 documents were sought for. Now, I have acknowledged the receipt of FCI New Delhi memorandum dated 19 August and revocation order number so-and-so dated 19th August.
Revocation order means revocation of suspension?
Yes, revocation of suspension. And the suspension was revoked is an admitted position, my lord. It is not denied. Now, by this letter, the petitioner sought certain documents, record, and time to submit the reply. So, on 7/9/2016, when this letter was submitted by the petitioner was still at FCI. It is only on 20th of September 2016 she was repatriated. Now, in the inquiry also, she initially appeared, sought time, then subsequently she could not. Her prayer for adjournment was rejected. And that matter proceeded expired. Now, lordship may come to page 71. It is the report of the inquiry officer dated 14/3/2018.
Page
71. It is the report of the inquiry officer. Inquiry report.
This is inquiry report?
Yes.
Okay. 71.
71. Lordship will see the first paragraph is introduction. Then comes the gist of charges.
What is the date of the inquiry report?
It is dated 14/3/2018. Lordship will see inquiry report. It is the introduction first, then the gist of charges.
Yes.
Then, my lord, prosecution witnesses, who are the witnesses examined. Then list of documents. Then dates of hearing, on which day a petitioner appeared and on which day the matter adjournment was sought for and the matter proceeded ex parte. Then 5, gist of the PO brief. Then, my lord, at page 77, just 3 lines conclusion. 6. Finding and conclusion of the inquiry officer. In the absence of the defense brief and in consideration of the submissions of PO, as also the documents on record, the undersigned is inclined to agree with the submissions of PO, and accordingly it is submitted that the article of charges are proved. No reasoning, nothing, no appreciation of the materials on record. Just 3 lines. Now this charge sheet, inquiry report was served upon the petitioner and communicated to the parent department. And then the parent department was also requested by the FCI to take a final decision on these findings.
When was it communicated to the parent department?
My lord, it was communicated to the parent department on 1/5/2018.
Any document? Page
No, madam,
79.
it is 9/1/2019, page 80.
No. Page number 79 is 1/5/2018 to the director, Women and Child Development Department, Government of Arunachal Pradesh. Serving of inquiry report.
This was to be served, forwarding.
Forwarding to the petitioner as well as to the director. And then on 9/1/2019, the formal request was made to the chief secretary to take action on the inquiry report. No, my lord.
Letter to the chief secretary is dated 9 January.
9 January 2018, 19, my lord.
So what transpired between 1/5/18 and 9/1/19? In between, what happened?
In between, after nothing happened, my lord. Once the inquiry report was communicated to the parent department for action under the report on 19/19 on
1/5/18.
no 9/1/2019, we approached this honorable court questioning the inquiry.
On 9/1.
After 9/1, this 9/1, then nothing happened in between, and we are before this honorable court.
9/1, it has gone to the chief secretary.
Chief secretary
From
the managing director,
Why
general
is-
manager vigilance.
Why such a long letter? This is again repetition of the
Charges and the repetition of the charges only. And again, the request, therefore, FCI regulation. So everywhere, my lord.
So this letter starts from page 80
Yes,
up till 93.
my lord.
GM vigilance.
Yes. From 80 to 93. So it is written everything, and then with a prayer that penalty, appropriate penalty. Appropriate penalty means, my lord, major penalty process. First, my lord has seen the inquiry report. apart from my submission that whether FCI could have inquired into it after a repatriation, even the inquiry report is also not tenable in law, my lord. Lordship has seen the inquiry officer in his report has not assigned any reason, the basis on which the conclusion was drawn. Simply 3 lines, my lord. In the absence of the defense brief and in consideration of so he agrees with the PO's argument and holds that all the charges are proved. Now, whether this is permissible under law. Now, in support, my lord, I'd like to refer 2017 to SCC 308. To SCC 308. Paragraph 7. We have given our anxious considerations to the submissions of the part. It is true that a writ court is very slow in interfering with the findings of fact recorded by a departmental authority on the basis of evidence available on record. But it is equally true that in a case where the disciplinary authority records a finding that is unsupported by any evidence whatsoever, or a finding which no reasonable person could have arrived at, the writ court would be justified, if not duty bound, to examine the matter and grant relief in appropriate cases. The writ court will certainly interfere with disciplinary inquiry or the resultant orders passed by the competent authority on that basis if the inquiry itself was vitiated on account of violation of principles of natural justice, as is alleged to be the position in the present case. Non-application of mind by the inquiry officer of the disciplinary authority, non-recording of reasons in support of the conclusion arrived at by them are also grounds on which the writ court are justified in interfering with the orders of punishment. The High Court has, in the case in hand, found all these infirmities in the order passed by the disciplinary authority and the appellate authority. The respondent's case that the inquiry was conducted, so all this is. Now, here in this case, although no finding, no punishment or penalty is imposed, but the basis on which the punishment is proposed to be imposed is the inquiry report. And the lordship will see in the inquiry report, no reason is assigned how the inquiry officer comes to the conclusion of guilt. Now, my lord, another decision . My lord, 2014, 9 SCC 263. 263, paragraph 38. Equally important and indeed fundamental to the policy of Indian law is the principle that a court, and so also a quasi-judicial authority, must, while determining the rights and obligations of parties before it, do so in accordance with the principles of natural justice. Besides the celebrated odi alteram partem rule, one of the facets of principle of natural justice is that the court authority deciding the matter must apply its mind to the attending facts and circumstances while taking a view one way or the other.
So, Gauhati, you're reading from which paragraph?
Paragraph 38. 2014 9 SCC 263.
Yes.
Non-application of mind is a defect that is fatal to any adjudication. Application of mind is best demonstrated by disclosure of the mind, and disclosure of mind is best done by recording reasons in support of the decision which the court or the authority is taking. the requirement that an adjudicatory authority must apply its mind is, in that view, so deeply embedded in our jurisprudence that it can be described as a fundamental policy of Indian law. So, my lord, application of mind is demonstrated by reasons, by recording reasons. Now, in the inquiry report, there is no reason. Now, in another case, my lord, (1990) 4 SCC 594. Paragraph 31. In so-and-so versus so-and-so, this court was dealing with an award of an industrial tribunal. It was found that the award stated only the conclusion and did not give the supporting reasons. Lordship, got it?
Yes, read.
Paragraph 31.
Yes.
This court has observed the giving of reasons in support of their conclusions by judicial and quasi-judicial authorities when exercising initial jurisdiction is essential for various reasons. First, it is calculated to prevent unconscious unfairness or arbitrariness in reaching the conclusion. The very search for reason will put the authority on the alert and minimize the chance of unconscious infiltration of personal bias or unfairness in the conclusion. The authority will adduce reasons which will be regarded as fair and legitimate by a reasonable man and will discard irrelevant or extraneous consideration. Second, it is a well-known principle that justice should not only be done, but should also appear to be done. Unreasoned conclusions may be just, but they may not appear to be just to those who read them. Reasoned conclusions, on the other hand, will have also the appearance of justice. Third, it should be remembered that an appeal generally lies with the decision of judicial and quasi-judicial authorities to this court by special leave so-and-so, so-and-so. Now 32, in so-and-so versus so-and-so, this court has laid down, it is now well settled law that where an authority makes an order in exercise of a quasi-judicial function. Now, my lord, I draw your lordship's attention to a fact that disciplinary proceeding is a quasi-judicial proceeding, madam. It must record its reason in support of the order it makes. Every quasi-judicial order must be supported by reasons. If court of law are to be replaced by administrative authorities and tribunal, as indeed in some kinds of cases, with the proliferation of administration of just the law, they may have to be so replaced. It is essential that administrative authorities and tribunals should afford fair and proper hearing to the persons sought to be affected by these orders and give sufficiently clear and explicit reason in support of the orders made by them. Then alone administrative authorities and tribunal exercising quasi-judicial function will be able to justify their existence and carry credibility with the people by inspiring confidence in the adjudicatory process. The rule requiring reasons to be given in support of an order is like the principle of audit partner, a basic principle of natural medicine, which must inform every procedural process and this rule must be observed in its proper spirit, and mere pretense of compliance with it would not satisfy the requirement of law. Then paragraph 39. The object underlining the rules of natural justice is to prevent miscarriage of justice and secure fair play. As pointed out earlier, the requirement about recording of reasons for its decision by an administrative authority exercising quasi-judicial function achieves this object by excluding chances of arbitrariness and ensuring a degree of fairness in the process of decision making. Keeping in view the expanding horizon of the principle of natural justice, we are of the opinion that the requirement to record reasons can be regarded as one of the principle of natural justice which govern exercise of power by administrative authority. The rules of natural justice are not embodied rules. The extent of their application depends upon the particular statutory framework whereunder jurisdiction has been conferred on the administrative authority. With regard to the exercise of a particular power by an administrative authority, including exercise of judicial or quasi-judicial functions, the legislature, while conferring the said power, may feel that it would not be in the larger public interest that reasons for the order caused by the administrative authority be recorded in the order and be communicated to the aggrieved party, and it may dispense with such a requirement. It may do so by making an express provision to that effect to those contained in the Administrative Procedures Act, so and so, so and so, whereby the orders passed by certain specific authorities are excluded from the ambit of the enactment. Such an exclusion can also arise by necessary implication of the nature of the subject, the scheme and the provision. For the reason aforesaid, it must be concluded that except in cases where the requirement has been dispensed with expressly or by necessary implication, an administrative authority exercising judicial or quasi-judicial function is required to record the reasons for his decision. So, my lord, the requirement of assigning reasons may be dispensed with in certain cases, but otherwise, my lord, every authority, be it judicial or quasi-judicial, the reasons should be recorded in the order that is passed. Now, my lord, in the case of Roop Singh Negi versus Punjab National Bank, 2009, Volume 2, SAC 570, the Honorable Supreme Court has held that departmental proceeding is a quasi-judicial proceeding. Paragraph 14. Lordship, paragraph 14. 14. 2009, Volume 2, SCC 570. Indisputably.
2009.
2009.
You've not given the list.
Oh, perhaps, my lord. Perhaps it escaped, my lord. I'm just reading, my lord. I'll hand over the copy, my lord.
No, just give me the citation first.
2009, Volume 2, SCC 570.
570.
570.
2009,
Volume 2, SCC 570. Paragraph 14.
14.
Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. So, in the earlier decisions, Lordship has noticed, the Honorable Supreme Court has held that quasi-judicial authorities should assign reason in the conclusion. So, departmental proceeding is a quasi-judicial proceeding, and the inquiry officer performs quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the party. The purported evidence collected during investigation by the investigating officer against all the accused by itself would not be treated to be evidence in the disciplinary proceeding. So, my lord, on this count itself, my lord, the inquiry report goes. It cannot be considered to be a legally acceptable inquiry report, and no action can be taken on the basis of this inquiry report. Now, coming to the decision of Supreme Court in that BSF matter, 2003-11 SCC 508, Shiv Prasad Pandey versus CBI.
You just get that. Sorry,
Paragraph 8.
Just a minute. Huh? No. 2009, volume 2, SCC 570. Chief Prasad Pandey, what is this paragraph?
Paragraph, my lord. Paragraph 8. And paragraph 22.
22, yes. This is on which point?
23 and 25.
Hmm?
Now,
3 and 25?
paragraph 23 and 25. Lordship has seen in this present case, although the petitioner was issued a charge sheet under the FCI regulation, after her repatriation to the parent department, my lord, the inquiry officer and presenting officer were appointed. The inquiry conducted and continued under the FCI regulation. Now, here in this case, Lordship will see the basic facts, paragraph 2, the facts of that case before the Honorable Supreme Court. The appellant belongs to Indian Police Service from Madhya Pradesh cadre. While so serving, the appellant was deployed on deputation to the Border Security Force in the year 1992. While he was in BSF, one so-and-so made a complaint to the authorities of BSF alleging certain misconduct of accepting illegal gratification for showing official favor against the appellant. Based on the said complaint of so-and-so, a court of inquiry was ordered by BSF and an additional so-and-so was appointed as staff court of inquiry. The said SCOI examined certain witnesses, including the complainant, and made a recommendation to the higher authorities that necessary disciplinary action may be taken against the appellant as per law. On the recommendation so-and-so, the Inspector General on so-and-so recommended that instead of initiating further action, the appellant may be awarded such and such punishment. Before any further action could be taken, either on the recommendation of so-and-so and so-and-so, the appellant was repatriated to his parent cadre of MP Police on 16/7/96. In the meantime, the complainant so-and-so filed another complaint against the appellant before the CBI on the same fact on which he had made the earlier complaint to the BSF authority. The CBI, on completing investigation, filed a charge sheet before the competent court. Based on the report filed by the CBI, the special court on such and such date framed charges and issued the charge sheet to the appellant. It is against the said framing of charges the appellant had filed the quashing petition before the Punjab and Haryana High Court. Since the special judge refused to say the proceeding before him during the pendency of the petition before the High Court, the appellant also filed a connected miscellaneous petition praying for staying of the proceeding before the special judge. It is these petitions which were disposed of the High Court by the impugned order. Now, my lord, and the argument was that before the High Court, the appellant has contended in view of the provision of Section 52 read with Section 57 of the BSF Act, the appellant cannot be prosecuted before the special judge because the appellant was already tried and awarded a minor punishment under the BSF Act. Therefore, there cannot be a second proceeding on the very same charge under the Prevention of Corruption Act. The High Court, noticing the fact that the award of so-and-so was only a recommendation and not actually an award of punishment under the BSF Act, rejected the said contention. Mr. So-and-so learned senior counsel appeared for the appellant before us contended that the special judge Patiala had no jurisdiction to try the case once initiated before the BSF authority under the said act. He contended that in view of Section 80 of the BSF Act, the criminal courts have no jurisdiction to try an offence allegedly committed by the appellant when he was serving in BSF. He also contended that even the preliminary question as to whether the BSF court had jurisdiction or not cannot be decided by a criminal court because it is a question which has to be decided by the BSF court only. He further contends that in the instant case, BSF authorities have invoked the so-and-so. So the petitioner appellant contended that since he was a BSF, so he is a subject of the BSF Act, so it should be confined under the BSF Act. Now, paragraph 8. The provision of the BSF Act is quoted. This section describes the persons who are subject to the BSF Act. Subsection 2 of this Act makes it very clear that a person once subject to that Act shall remain so subject until he retired, discharged, released, removed, or dismissed from the force in accordance with the provisions of the Act and the rules. Thus, it is to be noted here that as per this section, once the appellant ceases to serve the BSF in accordance with the provisions of the Act and the rules, he ceases to be a person subject to that Act. In the instant case, the appellant was deployed to serve in BSF while he was serving in the Indian Police Service, and on his repatriation to his parent department, he ceases to be an officer with BSF. Therefore, by virtue of section so and so of the BSF Act, the appellant ceases to be a person subject to the BSF Act from the date of such repatriation. And then the last, my lord, the concluding paragraph. For the reasons aforesaid, we are of the opinion that since the appellant has ceased to be an officer of BSF on the date of his repatriation, he was no more subject to the BSF Act. We are also of the opinion that the authority and the BSF had not initiated any trial against the appellant on the complaint of so-and-so, consequently the so-and-so, so-and-so, so-and-so. So, my lord, what I'd like to submit on reliance of this judgment is that once yes. Now, my lord, on reliance of this judgment, what I would like to submit before your lordship is, once a person is repatriated from the borrowing organization to the parent organization, then that borrowing, he no more remains a subject of the borrowing organization. So the acts and rules followed by the borrowing organization will not be applicable to that person. Here it is a case, my case is on the other way, my lord. Here the BSF, the Honorable Supreme Court says that since he was repatriated, the BSF Act will not be applied. In my case, since I was repatriated from FCI to Arunachal State Service, my parent department, the FCI rules and regulations will not apply. If that be so, my lord, the entire inquiry which commenced and continued under the FCI rules and regulation will not be made, will not apply to me, my lord, after my repatriation. No, my lord. Now, my lord, following this Honorable Supreme Court's judgment, my lord, a division bench of Madhya Pradesh High Court on a similarly situated cases has examined this provision. Lordship, 2014 legal MP 983. PL Satyarthi versus State of MP. Now, here, my lord, paragraph 7. In this case also, the petitioner, the person was an employee who was sent to a borrowing department, then repatriated, and then disciplinary proceeding initiated. Paragraph 7. We have considered the rival contention and we find that only question which warrants our determination as to whether after the appellant was repatriated from Madhya Pradesh Rajya Van Vikas Nigam, the disciplinary authority in the Nigam, namely the managing director, could initiate the departmental inquiry, and whether Rule 20 of the Madhya Pradesh Civil Service Classification Appeal Rules 1966 permits so. Lordship has Rule 20 of MP Civil Service Rule contemplates a position that in the matter of taking disciplinary action against the officer of the state government whose service are lent to the union government or any other subordinate or local authorities, for the sake of convenience, the provisions of rule is reproduced. Provisions regarding officers lent to the union or any other state government on any subordinate or local authority. where the service of a government servant are lent by one department to another, or to the union government, or to any other state government, or any other authority subordinate thereto, or to a local authority or other authority, the borrowing authority shall have the powers of the appointing authority for the purpose of placing such government servant under suspension, and of the disciplinary authority for the purpose of conducting a disciplinary proceeding against him, provided the borrowing authority shall forthwith inform the authority which lend the service of the government servant of the circumstances leading to the order of suspension of such government servant, or the commencement of the disciplinary proceeding, as the case may be. 2. In the light of the findings of the disciplinary inquiry conducted, now this 1 to 4 is the minor penalty, and now 3. If the borrowing authority is the opinion that any of the penalties specified in clause 5 to 9 of the rule 10 should be imposed on the government servant, he shall replace his service to the disposal of the lending authority and transmit to the proceedings of the inquiry, and thereupon the lending authority may, if it is the disciplinary authority, pass such order, or it may deem necessary, or if it is not, the disciplinary authority submit the case to the disciplinary authority which shall pass such order. The moot question is as to whether the procedure contemplated under Rule 20 as reproduced herein above is applicable only when the employee continues on deputation, or can be invoked even after the period of deputation is over, or the employee is repatriated back to his parent department. Now, in the case of Shiv Prasad Pandey, my lord, this is the Supreme Court judgment which your lordship has just now seen. This is the Shiv Prasad Pandey's case. The employee was working in the police department, and while so serving, he was deployed to work on deputation with Border Security Force. While working in BSF, because of certain offense committed by him, he was put to trial in accordance with the BSF Security Force Act much after he was repatriated back to the police department. It was held by the Supreme Court that on his repatriation to the police force, he ceases to be an officer of the Border Security Force from the date of his repatriation, and therefore he cannot be subjected to taking any action under the BSF Act. However, in the present case, the rules are different, and the action was taken after the repatriation from the corporation. Rule 20 of the so-and-so, as applicable to the state of Madhya Pradesh and reproduced herein above, gives power to the borrowing authority to take disciplinary action against a government servant who is on deputation, and the powers to the appointing authority and the disciplinary authority are conferred on the power of borrowing department. The rule contemplates that the borrowing department shall have the power of the appointing authority for the purpose of placing the government servant under suspension and for taking disciplinary action against them. But the proviso contemplates that the action taken has to be forthwith communicated to the parent department. When the power is given to any authority to suspend a government servant or initiate disciplinary proceeding against him, an assumption has to be drawn that the power can be exercised so long as the relationship of master and servant, employer-employee subsists, or the contract of employment is in existence. Once the relation of master and servant or employer-employee or the contract of service itself comes to end, the question would be as to how the disciplinary action or power to suspend can be exercised by an authority with whom the contract of employment of the employee concerned is no more in existence. Rule 20 therefore has to be interpreted by holding that the power conferred under Rule 20 to the borrowing department or authority to suspend the government servant or to take a disciplinary action against him can be exercised only if the relationship of master and servant or the contract of employment between the borrowing department and the deputationist employee subsist. When an employee is a government servant and holds a lien in a government department, is sent on deputation to foreign department or a corporation, then during the period of deputation, a temporary contract of service is brought into force between the borrowing department and the temporary employee concerned. And so long as its contract of employment subsists, the borrowing department can invoke the provision of Rule 20. But once the employee is repatriated back to the foreign department, then the contract of employment temporarily created during the period of deputation ceases. And if that be the position, then the borrowing department does not have the authority to take action against the employee concerned. Now, my lord, if we test the FCI regulation, my lord, I've just taken out certain provisions, but because this is a voluminous one, Now, discipline and appeal regulations, Lordship will see 54 is the penalties, 54, 1, 2, 3, Roman 6 minor penalties, and Roman 1, 2, 3, 4 Roman minor penalties, and 5 to 8 major penalties. And now at page 51, Rule 65, provision regarding officers borrowed from central or state government, government-owned organization, companies or corporation. Now, this is similar to that MP rules. Number 1, where an order of suspension is made or disciplinary proceeding are taken against a government servant or an employee of a public sector or private sector undertaking whose services have been borrowed from government or an authority subordinate thereto or such undertaking, the authority lending his service, which is referred to as lending authority, shall forthwith be informed of the circumstances leading to the order of his suspension or of the commencement of the disciplinary proceeding as the case may be. In the light of the findings of the disciplinary proceeding taken against the borrowed government servant, employee or public sector undertaking, 1, if the disciplinary authorities of the opinion that any of the penalties specified in clause 1 to 4 of regulation 54 may be imposed upon him, it may, after consultation with the lending authority, pass such orders as it deemed necessary. And number 2, if the disciplinary authorities of the opinion that any of the penalties specified in clause 5 to 9 of regulation 54 should be imposed upon him, it shall replace his service at the disposal of the lending authority and transmit to it the proceedings of the inquiry for such action as may deem fit. Now, my lord, the rule contemplates a situation, my lord, if the borrowing organization wants to go ahead with a disciplinary proceeding against a borrowed employee, they will conduct the inquiry, and if they want that a penalty, that is a major penalty, should be imposed, then the employee should be sent to the parent department for punishment. That means the power to initiate and continue the disciplinary proceeding can be exercised so long the person is in the borrowing department. Once the person is repatriated, then these powers cannot be exercised. This, my lord, 65 1 Roman 2 is very clear, my lord. If the disciplinary authorities of the opinion that any of the penalties specified in clause 5 to 9 of regulation 54, that is the major penalty, should be imposed upon him, it shall replace his service at the disposal of the lending authority. That means he should be repatriated to the lending authority for penalty, imposition of penalty, and transmit it to the proceeding of the inquiry for such action as it may deem fit and necessary. So, my lord, what it contemplates, my lord, so long the employee is under the borrowing department, you can initiate an inquiry, you can conduct the inquiry, you can continue with the inquiry, and if you want that a major penalty should be imposed, then you send him to the parent department with the findings of inquiry for the parent department to take an action. Here it is a case where the charge sheet was issued, and after issuance of the charge sheet, the employee was repatriated to the parent department. After her repatriation to the parent department, my lord, they could not have continued with the inquiry by appointing an inquiry officer and a presenting officer in terms of the FCI regulation. Because under the service rule, my lord, as an employee of the state of Arunachal, I am bound by the CCA rules. And the FCI regulations will be applicable against me only when I remain in the borrowing department of FCI. With my repatriation to my parent department, the master servant relationship comes to an end. So the rules and regulation of FCI, I no longer remain a subject of FCI, and the rules and regulations of FCI will not be applicable to me. And if that is so, then the inquiry which though initiated and continued under the FCI rules against me cannot stand. So if your lordship finds that the total inquiry by FCI is without jurisdiction, then it is the end of the matter. Without waiving that argument, my lord, without saying anything, even if your lordship holds that I can be proceeded under FCI, then also the inquiry report is not tenable because it suffers from unfairness, arbitrariness, as no reason is assigned. Now, if the inquiry report fails, then no action can be taken against me by the parent department also. Parent department can take action against me when the allegations are established in a properly or duly conducted inquiry, and an inquiry where the findings are in accordance with law. Now, so far, my lord, the charges are concerned, my lord. Lordship will see. Lordship may take my affidavit in reply, my lord. Against my affidavit in reply against the affidavit of FCI.
Page.
My lord, perhaps, my lord, it is page number 16 of my affidavit in reply.
What is it? This is a communication.
Yes, it is dated 13/12/2017. My lord.
Yes.
Now, my lord, lordship may have a look at the charge number 2. Article of charge number 2 at page 45 of my writ petition. Fraudulent payment of handling bills contract so and so, causing collateral loss of to the FCI to the tune of 84.78 crores. And the fraudulent payment was made to one contractor, MS SD Enterprise. Now, this is a letter. Lordship has seen the figure which I am highlighting, my lord, 84.78 crores. Lordship may have a look at this communication to the executive director made by the general manager. With reference to the subject cited above, so and so has advised that if FCI has ascertained the total loss incurred for default on the part of the contractor, money suit can be filed against the contractor after issuing notice to him. But to succeed in the money suit, you have to be sure of having sufficient evidence which would be required to be proved during the course of trial. Now, in this context, it is to state that this office has decided to file a money suit against so-and-so, but as per the legal advice obtained and so-and-so, it is to intimate that for filing money suit in the court against a party, details of exact amount of loss with documentary evidence is required to be put in the instant case. We have received now. It is important, my lord. We have received audit report from CAG, FCI headquarters, special audit team, and the amount of loss as calculated by the said respective audit reports are given below. Now, my lord, in one audit report, the amount is something, the other audit report, the amount is different, and the third report is something else. Now, here a question was asked, which audit report should be considered to be correct? Now, if they are themselves in a state of confusion, how can they maintain a charge of causing loss of 84.78 crores upon me? Lordship will see From the aforesaid statements, we are not in a position to ascertain which report is to be relied upon and which amount should be accepted as exact amount of loss to the corporation. Now, they are alleging that I have committed or caused a loss of 84.78 crores to FCI. Now, FCI's own document shows that they are not in a position to consider which document should be considered to be proper for ascertaining the loss. Further, it may be seen that the committee instituted by zonal office by letter dated 14/3/2016 submitted final investigation report dated 15/3/2016. Now, my charge is based on this report 13/5/2016 by mentioning total claim of 85 point something crores against the contractor on the basis of the subcommittee constituted by so and so so and so. The said subcommittee reported the excess payment made to the contractor on the basis of payment vouchers and reconciled bank statement for the relevant period. The details submitted by so and so. So now what they are seeking, my lord, next paragraph. In view of above, it may be seen that the assessment of actual excess payment made to the contractor on account of fraudulent claim calculated by final investigation team is not supported with the sufficient evidence to prove the case against the trial as advised by the advocate. Now, if that assessment is not supported by materials, how can a charge first of all be maintained against me for causing loss to that extent, and then a report of inquiry holding that charge to be established against me?
This communication is connected to which charge?
My lord, if your lordship this is the charge article of charge. This 14/3/2016 and submitted final report 13/5/2016. This is connected with charge number 2, and this document finds mentioned in the charge sheet, my lord.
Charge number 2.
Charge number 2.
At page 72.
Yeah. Charge number 2 at no, my lord. Charge number 2 at page number 45.
Product. Oh, no, this is number 1.
Fraudulent payment of handling bills or to the contractor, SD Enterprise. This is also SD. So now this question arose when the department wanted to file a civil suit against SD Enterprise, means She Doini Enterprise, SD. So when they wanted to file a suit against the contractor for excess payment, for recovery of excess payment, this question arose: what is the actual loss? We have 3 different reports, we do not know. And the final report, if your lordship takes up this report of investigation that 13/5/2016, that is last paragraph of page number 16. This 13/5/2016, has your lordship got it?
Page 16.
No, this is my additional affidavit page, reply affidavit page, which I was reading, that communication dated 13/12/2017.
Which part?
The last paragraph, it finds where your lordship will see that a final investigation report dated 13/5/2016.
Yes.
Second line of the last paragraph. Has the lordship got it?
Page 17.
Page 16. Page 16.
Oh,
Second line of the last paragraph.
yes.
13/5/2016.
Oh.
And this 13/5/2000 is a letter, or the report is an exhibited document in the inquiry. That your lordship will find mentioned in the inquiry officer's report at page 74. If your lordship takes up inquiry officer's report at page 74, the inquiry report, lordship will see that final investigation report dated 13/5/16 is an exhibited document. P6. So, first of all, you allege a charge by which you are alleging that the petitioner has caused a loss of rupees 84 point something crores to FCI by making excess payment to one contractor. Now, your own internal document shows that for a suit against the contractor, we don't have any evidence. And we have 3 different reports showing 3 different amounts. Which report we should be acted upon and what is the actual amount to be considered to be the loss occurred to FCI. In that context, they have sought a clarification and they made it clear that it may be seen that the assessment of actual payment, excess payment made to the contractor on account of fraudulent claim calculated by the final investigating team, that is the report dated 13/5/2016, is not supported with sufficient evidence to prove the case during the trial as advised by the advocate. Now, if that report or the loss assessed in that report is not supported by materials, then how come this charge of causing loss to the tune of 84.78 crore rupees to FCI by the writ petitioner can be established in an inquiry? And another interesting aspect Lordship will see in the inquiry proceeding, there is only reports. My Lord, Lordship, have a look at page 74 once again. What are the exhibited documents? Page 74. List of documents brought on record by prosecution. These are reports of investigation or CAG report or whatever it is. That is report dated so-and-so of the committee found by Journal Office, CVO report. Now, FCI's headquarters letter, these are circulars. These are all audit reports, investigation teams report and other things. Now, my lord, in an inquiry, my lord, where the allegation is of causing loss, whether these reports are per se evidence in support of the charges. These reports are just opinions of the person who conducted the investigation. Now, if I am alleged with an allegation that I have committed a fraud and misappropriated money. Now, a team is created for investigation and the team submits a report. Will that report be an evidence of that fact that I've committed this? That allegation has to be independently established in the inquiry. These reports can at best be the basis of forming an opinion to go ahead with a disciplinary proceeding. But these reports per se cannot be considered to be evidence in support of the charges. If there is an allegation of excess payment being made, that report will not be sufficient. There has to be further materials to show, yes, on such and such date, this amount was due, but this amount payment was made. There is no reflection of any other materials other than these reports in the inquiry. Now, the question is whether these reports, because these reports are only documents referred to in the charge sheet. Now, in my reply affidavit also, Lordship, I have drawn your Lordship's attention to the fact that there cannot be any allegation of missing truck against me. If your Lordship takes up charge number 1, then also Lordship will find that the allegation is I was responsible for those missing 41 trucks which were sent from Sensua in Assam. And the allegation is that Lordship may take up my affidavit in reply, the one which your Lordship was reading. Lordship may come to page 5, paragraph 7. it is pertinent to point out herein that a reading of the charge sheet served upon the deponent would go to show that the charge under Article 1 is without any basis. The deponent was posted at Bandardua and the trucks were loaded with rice as Sensua in the district of Nagaon, Assam, which is admittedly under the jurisdiction of FCI Nagaon district and not under the deponent. The carriage contractor was neither appointed by the deponent nor did the deponent have any control over the dispatch of rice through the trucks of the carriage contractor. The deponent was the recipient of the goods only to be delivered at Tawang and Separ depots, which were under her jurisdiction, and as such, no fault can be attributed to her in respect of dispatch of goods from area outside her jurisdiction. Hence, to blame the deponent for not receiving the consignment and frame charges on this count on an estimated loss of 1,11,20,332 is highly improbable and illogical. It is further stated herein that the issue of non-receipt of consignment for Tawang and Separ depot were taken up by the deponent with the general manager, regional office of Itanagar by email dated so-and-so with copy marked to area manager Nagaon, as well as letter dated so-and-so addressed to area manager Nagaon. As such, it is totally unjustified to shift the entire burden upon the deponent and frame charges of estimated loss caused to FCI. So, my lord, the allegation is certain number of trucks were sent from Nagaon to Tawang, but it did not reach there. And I was made responsible for the entire thing. Now, another allegation is that I failed to abide by the instructions. Now, if your lordship takes up this affidavit in reply at page 15, so my allegations are that I did not follow the instructions of the higher authorities and did certain acts. Now, this is a circular of FCI dated 24/10/2017. It has been observed by the audit committee that the circulars issued by FCI headquarters are not flowing to the level of district office of FCI, and the circulars are communicated only up to the level of zonal office and regional office. It is therefore advised to all the zonal office and regional office to further circulate the circulars issued from headquarters to the district office under their jurisdiction. So, my lord, they are saying that you have not followed the circulars. You are not acted on the basis of the circular. Their own document shows that the circulars issued are not reaching the district level office. These are kept in the zonal office or the regional office only. Now, if it is observed, it is their own observation that circulars, it has been observed by the audit committee, the circulars issued by FCI headquarters are not flowing to the level of district office of FCI. And the circulars are communicated only up to the level of zonal office and regional office. Now, you don't communicate the circulars to me and then you allege that I do not follow the circulars.
What was the circular about?
They are saying that I have not followed the circulars.
What is that circular?
If your lordship comes to page number 44, in respect of article charge number 1, page number 44, non-compliance of FCI headquarter road movement circular number so and so and so and so. As per circular so and so, road movement is to be reconciled and monitored by the area managers on daily basis, which are not put into action in the instead case. Area managers on daily basis. Who are the area managers? Who will monitor whether the area manager from where the trucks were sent or not? So basically, the allegation is that I have failed to follow the circular. Now, their own document shows that the FCI circulars do not reach the district level. It remains in the regional or the zonal level only. That is why in 2017, it was specifically made clear that the circular should reach the district headquarters also. So, my lord, the following facts comes, my lord. Upon issuance of the charge sheet, till I was in FCI on deputation, I made a request by letter dated 7/9/2016 to the CMD for certain documents, so that I can reply the charges and short time of certain period, 90 days. Documents were not given because the charges, allegations, when the charge sheet was issued in 2016 and the irregularities happened in 2010, 11, 12, 13, for a long period back. So I requested those documents, certain documents regarding the contract files, how the contractor was appointed, what are the contracts under which the payment ought to have been made. So these documents being relevant were asked for by the Lordship. Will have a look at page 69. Sir, you have mentioned that I should have submitted my reply within 10 days of receipt of this letter, which is not possible for me, as you are well aware that I am the deputationist from the state government and not aware and well versed with the rules and staff regulations of FCI. I will be requiring all the documents related to the matter relating to contracts and storage for the period so and so accounts from this DO Bandardua and RO Itanagar for furnishing the reply on the above said memorandum. It is informed that up to June 22, all the depots were controlled by RO Itanagar only, in which the order copy will be enclosed in my reply. I have acknowledged and gone through the letter of memorandum and charge sheet issued to me, which is very voluminous in nature, and the sections and articles framed against me are pertaining for a period 3-4 years. So I will not be in a position to reply the memorandum in 10 days. So I request for 90 days time. Now, thereafter, again, during the inquiry also, even assuming my lord, I do not file any reply. That non-filing of reply will not amount to admission, my lord. Here, that is why an inquiry was initiated. In the inquiry officer, before the inquiry officer also, I made a request for certain documents with details. These documents were also not handed over to me. So basically, my lord, my case is first. My first ground of challenge is after my repatriation from FCI to the state government, state service of Arunachal, FCI had lost its right to go ahead with the inquiry. Because, my lord, FCI, even if I stayed at FCI, FCI could not have imposed a penalty of any major penalty upon me without the parent department. That is why their own rule postulates that if you want to get a major penalty imposed upon a deputationist, you have to send him to the parent department with the report of inquiry. That is what Rule 65 of the FCI rules provides.
Isn't that what they have done?
No, they have not. They have repatriated me before they have committed, conducted the inquiry. That means.
So you should be repatriated back with the findings of the inquiry.
Yes, now you can go ahead with the inquiry, provided I stay in your department.
In the FCI.
In FCI. Once you repatriate me.
Once the inquiry is over, penalty will be imposed by the parent department.
Parent department, and at that time, now if after the inquiry, if it is found that a minor penalty may be imposed, then the borrowing department, the FCI, could have imposed that minor penalty in consultation with my parent department, parent organization. But they are insisting for a major penalty. That can only be done when I am sent back to the parent department, and that punishment should be imposed by the parent department.
You are reading that regulation
65.
65. Which particular regulations? One, there's 1, 2, 3, then 1 and 2.
If the disciplinary authority is of the opinion that any of the penalties specified in clause 5 to 9, regulation 54 should be imposed on him, it shall replace his service at the disposal of the lending authority and transmit to it the proceedings of the inquiry for such action as it may deem necessary. So that means I should be in FCI so long the inquiry goes. It is only at the time of imposition of penalty I should be sent back to my parent department with the proceedings of inquiry for my parent department to impose the penalty, if it is a proposed major penalty. Now here what they have done, they repatriated me before the inquiry commenced. The inquiry officer was not even appointed on the day when I was repatriated. With my repatriation, they lost their right, or rather they have waived their right to proceed against me under FCI regulation. That is why, my lord, though it is not there, my lord, I requested for conducting the inquiry by my parent department.
You had requested that?
Yet.
Where's that?
Yes, my lord, I'm finding it. Just here we take out. Page 58, my lord. This is a letter of the petitioner to the parent department. I am to apprise you that the departmental proceeding has been initiated by FCI under memorandum. The same memorandum issued to me without hearing in person, and a letter of request was apprised to the vigilance in written statement and headquarters. So the accounts who were deputed by FCI to investigate the matter did not contact me nor hear in person. Also, a letter of intimation was written to MD regarding the matter, but whatsoever the request was not looked into in urgency, but on so-and-so, I received a letter from so-and-so. Therefore, madam, with all these types of lacunas and complications, conspiring against a deportation is not desirable. So I highly request you to appoint an IO and PO from my own parent department to attend my hearing. So, my lord, the petitioner wanted the same inquiry to be conducted by the parent department. After a repatriation, the petitioner wanted, okay, I'll face the inquiry, but it has to be conducted by my parent department.
This was written in 17/1/2017.
Yes, ma'am.
Memo charge was issued in 19 August 2016.
19 August 2016. Inquiry officer and presenting officers were appointed on 24/11/2017. and inquiry commenced on 25/7/2017. The actual inquiry started, if your lordship takes up the inquiry report, lordship will find that inquiry commenced from 25/7/2017. So before the commencement of the inquiry by FCI, that letter was written.
What is this 11/1/17?
My lord.
Page 58, which was, we're just reading. Petitioner says that on 11/1/17, she received the letter from the AGM vigilance.
And a letter of request was apprised.
To hear me after a gap of 8 months.
A written statement and inquiry on 11/16. So
What is
perhaps that is not on record.
11/1/17.
The fact remains, my lord, I wanted the inquiry to be conducted by my parent department. Because by that time, the inquiry officer was appointed.
No, our main contention here is that she was not given a chance to hear, to be heard in person. And instead, despite that, they have initiated they have given her the memorandum of charge. According to us, she should have been heard first. That hearing was not done. So ultimately, some letter was given to her on 11/1/17. Okay, we'll hear you now. That is after 8 months.
And another thing, my lord, but the most important aspect is whatever this is going on, whatever that happened, it happened after a repatriation. So if your lordship appreciates the fact that after repatriation of the petitioner from FCI waived their right of going ahead with the inquiry.
No, that what you have stressed.
My lord.
That is your main thrust.
My lord. If that goes,
Of argument.
the entire inquiry falls. And I am relying on that two decisions, one of the Honorable Supreme Court in that BSF matter, which says that once a BSF person, a person on deputation to BSF, if repatriated to the parent department, he ceases to be subject of BSF and not be applicable. BSF Act will not be applicable. Here also, my lord, the same thing. Once I am repatriated from FCI, the FCI rules and regulations will not be applicable. That is why the inquiry or the disciplinary action which was initiated under the FCI regulation will not be applicable. Second, my lord, is that their own document shows that the allegation of causing loss to the tune of such and such amount is not correct. There are three different reports. Lordship is aware that when you allege in a charge sheet, the charge must be specific. Now you are alleging a specific, leveling a specific charge that I caused a loss, caused a loss of rupees so and so upon FCI. And this is based on certain reports. FCI's own document says that there are reports showing three different amounts. Which amount should be relied upon? Now, if that is their own document, how can they level a charge of such and such? This charge itself goes. You don't have any material for that charge. And You are saying, their own document is saying that the report is not sufficient enough to, the documents in the report are not sufficient enough to come to the conclusion that this is the lost cost. So meaning thereby, this very charge itself is vague. You don't have any materials in support of the charge. At least the charge sheet does not disclose. Charge sheet only disclose certain investigation reports, which per se is not evidence, documentary evidence to bring home the charge.
Let us see your pleadings. What have you stated in the writ petition?
Now, the grounds, no, these are all, everything what I have pointed out, my lord. Everything is there. Now, paragraph 31. It is apparent on the face of the record as transpired from the inquiry report, the inquiry officer failed to make any independent assessment on the allegation lodged against the petitioner. He simply relied on the various reports placed before him and accepted them. Thus, the finding of inquiry officer suffers from non-application of law. The petitioner submits the author failed to provide the documents. So, the document. Paragraph 16, which my lord, we made a statement that the managing director FCI by another order dated 19/8/2016 revoked the order of suspension. Paragraph 16, and this is an admitted position. The revocation of the suspension order.
I found it somewhere else also.
That is that letter of at page 69.
How long were you suspended?
My lord, I was placed under suspension by order dated 24/5/16.
About 3 months.
Not, it is just
Less than 3 months.
less than 3 months. Suspension was revoked.
What did you get during the suspension? Allowance?
Perhaps, my lord.
That issue is not raised. Otherwise,
This is not an aspect. And interestingly, my lord, I was posted at Itanagar regional office, and the day I was suspended, I was brought to Gauhati and kept here at Gauhati for 3 months. Along with my suspension, I was transferred also. I was kept at Gauhati for 3 months. Then after 3 months,
where in Gauhati?
Zonal office at Gauhati.
Zonal office.
At Gauhati.
FCI.
Of FCI.
I see.
So for 3 months, then suspension revoked, then I was repatriated. So
that you don't tamper with the evidence.
They don't.
There must be the reason.
But
otherwise, why should he be brought here?
My lord, if any evidence, that evidence would have been in the district office at Bandardua. I was from district office, I was transferred to regional office, from regional office to Gauhati office.
Regional office in Itanagar.
Itanagar. From Bandardua.
It's nearby.
Itanagar.
Itanagar, Bandardua, how much? 45 minutes.
So I'm not on those aspects, my lord. My first ground is that after repatriation, it could not have been, FCI could not have carried out or gone ahead with the inquiry. Number 2, my lord, the charges, first charge, second charge, lordship will see that these are vague charges. You could not have imposed leveled any allegation. And the entire inquiry, the FCI is relying on certain reports, investigating reports. because my lord, this investigation report in that Rup Singh Rathod's case, Rup Singh Negi's case, which your lordship, I could not give a copy, 2009 2 SCC 570. At paragraph 14, Honorable Supreme Court holds the purported evidence collected during investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceeding. Now that here it is an investigation report or an audit report, and the audit report is based on certain examination of certain documents and other things. Now, that report by itself will not be evidence in support of the charges. So it has to be independently established. It can at best be a material for forming the opinion to go ahead with the inquiry or initiate an inquiry, a disciplinary proceeding. But investigation report per se will not be evidence. You cannot allege anything on the basis of investigation reports. Moreover, my lord, there is a CBI case pending against me, and it is going on for a long time. Till date, my lord, the trial is going on. Witnesses are not coming, and a criminal case is going on. So, my first argument is no inquiry after repatriation. Second, my lord, the inquiry officer's report is not tenable, my lord. It cannot be accepted. It is absolutely against the provision of law. No action can be taken on the basis of such inquiry report, as it has failed to assign any reason for coming into conclusion to the effect that all charges are proved. What are the documents? How? Just accepts the PO's argument, which is of course not the job of the inquiry officer to blankly accept everything. No reason.
Okay.
So
Let us hear the other side.
my lord, and I'll
May reply.
I'll reply.
So Melo, the three.
What is your good name?
BK Singh for FCI, Melo.
BK.
BK Singh.
BK.
B for Bombay. I'm appearing for the respondent number 1, 2, 3, and 4, Melo.
1 to 4.
1, 2.
Yes.
So, my lord, my learned friend has raised three basic questions that has to be answered. First of all, that after repatriation, FCI should not have continued the proceedings, my lord. Secondly, the allegation that the charge is vague. But with regard to the charge is vague, there is no pleading, my lord. And thirdly, the inquiry report not assign any reason. So, my lord, kindly just note down the important date, my lord. The memo of charges, the disciplinary proceeding has been initiated by issuance of the memo of charges, that is on 19/8/2016, my lord. This date is important. So the disciplinary proceeding has been initiated, and thereafter the on 29/2016, petitioner was relieved from her duties, and I think she was repatriated on 29/2016. Thereafter, 24/11/2016, appointment of inquiry officer was done, my lord, and on the same date by another
24/11, correct?
24/11/2016. That is annexure P to the writ petition. And by the separate order dated 24/11/2016, that is annexure Q, the presiding officer was appointed, my lord.
Same date.
Same date, my lord, but with different order. My humble submission would be, my lord. The disciplinary proceeding has started not after the repatriation of the petitioner, but before the repatriation, my lord. So what I am submitting that the disciplinary proceeding has already started by issuance of the memo of charges asking the petitioner to reply on the certain charges, my lord. Now, my lord, from page 112, this is a running page, my lord, of my affidavit in opposition. I would be relying on para 7, 8.
Page?
Page 112, it starts, my lord, running page. Affidavit in opposition filed by the FCA. We have narrated through chronologically by way of list of evidence, my lord, and who were the
Paragraph 7.
who were the officers who have been category 2 officers, my lord, which were the inquiry was held separately, and the petitioner being the category 1 officer, separate inquiry was held, my lord. So, my lord, paragraph 7. From the middle part of it, I will read it, my lord. Let me start from the very first line, man. That with regard to the statements, with regard to the statement made in paragraph 18 and 19 of the writ petition, the deponent begs to state that the pursuant to the initiation of the departmental proceeding by memo of charges dated 19/8/2016, the disciplinary authority by 2 separate orders on 24/11/2016 appointed Sri B. Devanand, DGM General, and Sri Gaurav Power, Assistant General Manager Accounts, Zonal Office, Notice, Gauhati, as an inquiry officer and presenting officer respectively in the departmental inquiry initiated against the petitioner by memo of charges dated 19/8/2016. The appointment of the inquiry officer as aforesaid was also intimated to the petitioner, Srimati So-and-so. It seems that the petitioner soon thereafter, in order to avoid appearance before the inquiry officer appointed by the FCI authority, submitted an application before her parent department requesting the said authority of the state government to appoint inquiry officer and presenting officer for conducting the departmental inquiry initiated against her by the FCI by memo of charges dated 19/8/2015. Even knowing fully well that neither the rules of the procedure prescribed under the CCA rules 1965 nor the FCI staff regulation 1971 provides any option for a delinquent officer to make such prayer. I will come to those rules, my lord. However, the petitioner from here it is important, my lord, dates. However, the petitioner on 25/7/2017 and 26/7/2017 appeared before the inquiry officer appointed by the FCI authority during the course of the preliminary hearing on for document verification and appointment of defense assistant. When the petitioner appeared, only denied the charges, my lord. On appearance before the inquiry officer, the petitioner has only denied the charges, my lord. Later, however, on 9/8/2017, she submitted an application for providing her certain documents to her, but she did not appear in the subsequent proceeding, that is 24/8/2017 and 25/8/2017. And only intimated by her letter dated 24/8/2017 that due to enrollment of Aadhaar card for Dulari Kanya scheme and Pradhan Mantri Matri Vandana Yojana, which was stated to be very important scheme, she was unable to attend the inquiry proceeding. Later, when the inquiry proceeding was fixed again on 26/10/2017 and 27/10/2017, the petitioner, without attending the inquiry proceeding, sent a email on 26/10/2017 stating that she was preoccupied personal presence. Again, when the proceeding was fixed on 29/12/2017 and 30/12/2017, the petitioner intimated via her email dated 28/12/2017 that she was not be able to attend the hearing as she was on medical leave. The inquiry officer, however, in terms of the mandate provided by under the FCA staff regulation 1971 to complete the proceeding with the definite time frame, recorded the deposition of PW1 as K. Pramani. When again the proceeding was fixed on 10/1/2018 and 11/1/2018, the petitioner avoided attending the departmental proceeding, when the inquiry officer recorded the deposition of Sri Nitin Khurana, Jaiprakash, and Amit Kumar Singh. When the proceeding was fixed again on 23/1/2018 and 24/1/2018, the petitioner did not attend even on those dates. when the inquiry officer recorded the position of Sri Inder Kumar Negi. Lastly, when the matter was again fixed on 2/2/2018 and 3/2/2018, the petitioner did not attend the said dates of hearing. However, the inquiry officer had recorded the deposition of Sri Asunang Naglum as PW witness. Thus, the petitioner, after her initial appearance on 25/7/2017 and 26/7/2017, did not attend the hearing deliberately, apparently in order to frustrate the purpose of departmental inquiry initiated against her gross misconduct. Thereafter, my lord, paragraph 8, that with regard to the statement made in paragraph 20 and 21 of the writ petitioner, the deponent denies that the inquiry officer conducted the inquiry against the petitioner in a common proceeding along with Sri T. Borgohain, Jogeshwar Rajvanshi. There was an allegation in the writ petition that the joint proceeding, departmental proceeding was held. That we have clarified, my lord, because they were category 2 officer and petitioner was category 1 officer. The petitioner was since category 1 officer, her proceeding was done separately, my lord, not with the other officers, my lord. It is, however, stated that common disciplinary proceedings were initiated simultaneously against various officers, but the proceeding against the writ petitioner was independent of those proceedings, though some were grouped together for common inquiry under Regulation 60 or 62 of the FCI Staff Regulation 1971, keeping in view of the category of employment that the delinquent employee belonged to, and also for the convenience of the inquiry proceeding, basing on the nature of the misconduct committed. It would be pertinent to mention herein that the memorandum of charges under Regulation 58 of the FCI, Regulation 1971, were initiated against a total number of 25 officers, including the writ petitioner, based on CAG audit observations, special audit conducted by the FCI headquarters and the Journal of Vigilance Office investigating report, wherein it was observed that by the audit team that fraudulent access payment to the tune of rupees 80 crore approximately was made to Sri Gorga Makik, contractor proprietor of Sahidoni Enterprise, Arunachal Pradesh, by all the said officials of the FCI District Office Bandardeva since 2012. Though the disciplinary proceeding against the petitioner was conducted separately, yet common proceeding against other officers were conducted basing on the category of service belonged to and the nature of misconduct committed each of them. The inquiry proceeding against all of them were, however, conducted by the same inquiry officer simultaneously so as to avoid inconsistency and ambiguity in proving finding against the actual delinquents. Moreover, the witnesses' documents in respect of each of the proceedings were by and large same. The same matter also comprehends investigations by the CBI Gauhati, wherein 4 numbers of FIR were lodged by the CBI against the few delinquents, including the petitioner, who was sent up by the CBI by issuing a charge sheet on 27/12/2017. Presently, the entire CBI investigation and charge sheets are under sub judice before the Honorable Court of the Special Judge at UPI Arunachal Pradesh. Since the writ petitioner was on deputation in the FCI and in the meantime was repudiated, the FCI, as the borrowing department, had to transmit the proceedings of the inquiry to the lending department for appropriate actions and impose certain strict penalty for the irregularities, fraudulent payment, misappropriation of stock, resulting in huge loss to the tune of rupees 86.30 crores approximately, as per the finding of the inquiry proceeding. Penalty imposed on other delinquents found guilty of misconduct against whom charges are not proved following inquiry conducted simultaneously are as under. So, my lord, the following were the category 2 officers, my lord. There were as many as 24, my lord. Some were proved, some were not proved, my lord. Like in number 1, Satyan Das, it was proved recovery of 50,000 from terminal dues and other gratuity. The penalty, my lord. Third column is penalty. Then 1 PC mainly proved Mayur Datta. Mayur Datta case was proved, but it was now this proceeding is before, my lord, the Honorable Supreme Court, my lord. And others who have the proceedings were proved, they did not approach this Honorable Court, my lord. They have accepted the penalty, my lord. Except Mayur Datta, I have stated that the case is pending before the.
But the punishment was interfered with by this honorable court on the ground that the charges were vague. Charge sheet was vague. Mohit Datta, an appeal was filed, the appeal was also dismissed. That is how it is before the Supreme Court, not by Mohit Datta challenging the punishment. That is pending before Supreme Court because this honorable court interfered with the finding on the ground that the charge sheet is.
So those judgments are stayed, my lord, and it is pending before the Honorable Supreme Court, only against Mayur Datta, my lord. They, but in this case, that the charge is back is not pleaded by the petitioner. my lord.
What about the others? No one has filed case
No, no one has filed case.
except for the petitioner and Mayur Datta.
Yes, ma'am.
They are all, Mayur-Datta, all they are FCI employees. Not
These are
like
all FCI
petitioners,
employees.
Which are deputations.
No,
They are
no.
all FCI.
We're not saying that they are not same employees. I'm saying that since they have been also charged, whether any litigation is pending.
So, my lord, paragraph 9, we have given the detail as per chronologically how the case inquiry was proceeded, my lord. Para 9, my lord. That we regard at page 117.
See, but one thing, what is your response to the specific submission made by Mr. Chakrabarty regarding after repatriation, you cannot sort of, like. any other the FCI
Has misinterpreted, my lord. My lord, we have filed also to IA, my lord, for vacating of the stay order and another IA for taking up the matter for early hearing, my lord. Any IA may be taken up, my lord. Let us take the IA number 3609.
609.
Here we have explained, my lord.
This is for early hearing
3609
or vacation.
for vacation of interim order, my lord. Page 15, my lord.
Just a minute, huh? Yes,
Page 15, para 31, my lord.
yes, read.
That the above letter so and so has been issued by the FCI New Delhi in accordance with
What is this
that
letter?
9/1/2019, when after the inquiry was over, the inquiry officer has he submitted the inquiry report to the state government of Arunachal Pradesh, that
To
is
the
by
Chief
letter
Secretary.
dated 9/1/2019 to take appropriate step.
General Manager Vigilance had submitted to the Chief Secretary.
Yes, my lord, to take appropriate to take appropriate steps, my lord. There are 31, ma'am. That the above letter 9/1/2019 has been issued by the FCI headquarters New Delhi in accordance with the provision contained in Regulation 65(2) Roman 2 of the FCI Staff Regulation 1971 and the CBC Vigilance Manual 2017, point number 7.4 and chapter 3 of the Handbook for the Inquiry Officers and Disciplinary Authority issued by the Government of India, Department of Personnel and Training, Ministry of Personnel, Grievance and the so those provisions has been quoted, my lord, from para 32 onwards, my lord. Para 32, my lord, regulation 65. At page 17, my lord, Roman 2 may be. May I take your lordship to Roman 2, my lord?
Yes.
If the disciplinary authority is of the opinion that any of the penalties specified in clause 5 to clause 9, regulation 54 should be imposed on him itself, replace his services at the disposal of the lending authority and transmit to it to the proceedings of the inquiry for such action as it may deem. Inquiry only, it can be, one can come to the conclusion that no, it's minor, not it's major penalty is required, my lord.
No, that's okay.
So
Question-
let me.
Question is otherwise.
Other provisions, my lord.
Whether you can go ahead with the proceeding.
My lord, because
After
that's why
repatriation.
that's why, my lord, I have pointed out the first charge of memo. This disciplinary proceeding has been initiated on 19/8/2016 before the.
But after initiating, you have repatriated him.
Yes, my lord.
So can you still pursue that matter? This is the question, ma'am.
We can, my lord.
There's no but.
They're under regulation 65(2), my lord, and also the CBC Vigilance Manual.
65
and
speaks about the penalty which can be contemplated. It has to go back to the parent department.
In the regulation, nowhere it is written that the inquiry officer cannot conduct the inquiry, my lord, after repatriation, my lord. Then para 34, my lord. That is chapter 23 of the handbook for inquiry officers and disciplinary authority issued by the government of India, Department of Personnel and Training, Ministry of Public Grievances and Pension is abstracted as under borrowed and land officers. So, my lord, the number one, what are the powers of an authority to deal with the misconduct committed by an employee who has been borrowed from another organization? Borrowing authority shall have the powers of appointing authority for the purpose of placing the delinquent employee under suspension. Then number two, can the borrowing authority initiate disciplinary proceeding? The borrowing authority can initiate the disciplinary proceeding, but the powers for imposition of penalty depend upon the circumstances of the case.
Okay, this is chapter 23 of
Chapter 23
borrowing.
of Handbook of Inquiry Officers and Disciplinary Authorities issued by the Government of India, Department of Personnel and Training, Ministry of Personnel Department. Then at page 19, my lord, it has number 5, my lord. Briefly, what are the powers of borrowing and lending authorities? May I read that one, my lord. Powers of borrowing authority may be summed up as under, it can suspend.
Where?
Page 19, my lord.
19.
Number 5, briefly, what are the powers of borrowing and lending authorities? Powers of the borrowing authority may be summed up as under, it can suspend but should not report the matter to, but it should report the matter to the parent department. It can initiate disciplinary proceeding. It can impose minor penalty subject to consent given by the parent department. It will have to repatriate the employee if it is of the opinion that the major penalty is required to be imposed. Findings of the inquiry conducted by borrowing department are not binding on the lending department. Lending authority is at liberty to conduct further inquiry as deemed necessary. So, my lord, my humble submission is that the disciplinary proceeding has not yet completed, my lord, after the inquiry officer, my lord. It has been submitted to the lending authority to take action. Once the lending authority will take the appropriate decision, or may not agree also with the findings of the inquiry officer, my lord, then only this disciplinary proceeding will be completed. That is my humble submission, my lord.
So it is at the stage of regulation 65.
Yes, my lord.
Subclause Roman 2.
And since that, after that, they have approached this honorable court, and the honorable court was pleased to stay that 2019 letter, matter. Now, coming back to the prayer of the petitioner, my lord, at page 16.
Just a minute. Just a minute. Yes.
I want to place another order of the government of Arunachal Pradesh, madam, at page 107, madam, running page.
In the main petition. 107.
Yes, page 107. This is annexure 4, annexed to the affidavit in opposition of the government of Arunachal Pradesh, madam.
Running page 107.
107, madam.
Running page is not there, but it is the affidavit of 567.
Affidavit, my lord, of the government of Arunachal Pradesh.
Mr. Adhikari, you have you are the government advocate.
Yes.
For Arunachal.
Not that annexure.
107. Yes.
Yes, 107. Order dated 8/4, Roman 4. Order dated 8th August 2017. Srimati Moyung CDPO Naharlagan. ICDS project Naharlagan is hereby allowed to attend regular hearing as the prosecution witness on 9/8/2017, so and so. Now, I will come to their.
This in a connection.
Well,
with another-
paragraph 18, my lord, paragraph 18, page 99.
This is in connection with another case.
Yes, my lord, in other case, my lord, where the inquiry was going.
Who are
Para
these?
18.
Who are these officers? Satyan Das and he was the ex-manager general.
Yes, because yes, my lord. They were category 2 officers, but
Just a minute, Satyan Das.
my lord, the paragraph 18.
But where is the name of Satyan Das in your affidavit?
No, my lord.
Huh? You had taken some names. Paragraph 8 of your counter.
States counter, my lord. Satyan Das, my lord, we have, they were the delinquent officer, my lord, category 2 officers, wherein the.
Not correct. That's why you had, there are a list of officers here, okay?
Yes.
At page
114.
112 and 114 also, perhaps.
Yes, my lord,
But
114.
where
it
is
starts.
Satyan Das? Satyan Das doesn't have
Satyan Das, number 1, my lord,
where? 114?
page 112.
114. Okay, Satyan Das. Recovery of 50,000. Okay, on gratuity. Now, thing is that if you have taken me to page 107.
Now, that is not relevant, my lord. I want to.
No, you have taken me to this page, so let us clarify that.
Yes, my lord.
If it is not relevant, you shouldn't have shown me this page. Now that you have shown me, Satyan Das and ex-general manager was proceeded against.
Yes,
And
ma'am.
you stood as the one of the prosecution witness.
No, the petitioner in the other disciplinary.
I mean, I'm sorry, you means petitioner, yes.
petition.
That means the petitioner, the charge which is leveled against the petitioner, and in context of the similar charge, another employee of FCI is facing, my lord, disciplinary proceeding, and the petitioner is made a witness there. Indirectly, the petitioner is
I want
asked to.
let me complete it. My lord,
give
I want to,
evidence against
take your lordship at page 99, para 18, my lord, of the affidavit in opposition of the government of.
What did you want to show me by taking me to this 107?
No, my lord, paragraph 18 is stating something else, my lord. Para 18, page 99.
Page 99.
They have annexed the wrong,
Paragraph 18.
18, my lord. May I read it, please?
Yes.
That with regard to the statement made in paragraph 26 of the writ petitioner, your deponent states that the petitioner was permitted to attend the regular hearing as prosecution witness on a white order written, and as such it is denied that the petitioner could not attend the subsequent proceedings of. What my learned friend is submitting, that as per her letter dated C1, that the inquiry officer of her department, or she was not, my learned friend is saying that she was allowed to participate in the proceeding
This is
against
not.
her. But
This
the
is-
document is saying something else.
Document is saying something, pleading is saying something.
Mr.
In fact, my lord,
Let me complete. So, my lord,
No, what you wanted to say was that the department itself had permitted her to participate,
lord.
go
Only
and
that-
participate.
only that part of
But that document is not there, it's showing something else.
Yes, my lord. She was taking all those pleas, my lord, available to her that not to participate in the proceeding, my lord. So, my lord, I was referring to the paragraph.
Not only the document, but your statement also saying something else.
Yes. No, government of Arunachal Pradesh.
This is from government.
Government of Arunachal Pradesh.
5, 6 and 7.
Okay.
No, not FCI.
FCI is relying on the statement of government of Arunachal.
Only on the part that she was allowed by the government of Arunachal Pradesh to participate in the disciplinary proceeding against her, which was ongoing against her. So, my lord, I'm referring to the prayer of the writ petitioner at page 16, my lord, of the writ petition.
Yes.
The prayer number 1, a writ of certiorari shall not be issued to set aside the common inquiry proceedings held against the petitioner by the authorities. So, my lord, there is no common inquiry, my lord. Petitioner's inquiry was held separately. Number 2 prayer, writ of certiorari shall not be set aside and cause the inquiry officer report dated so and so. And then the third is set aside the that 9/1/2019 issued to the chief secretary. So, my lord, coming to the, first of all, my first submission against the first question raised by my learned friend that the FCI ought not to have started the proceeding after repatriations. The proceeding has started on 19/8/2016, my lord, and thereafter he was repatriated. And all the documents, all the witnesses were from the FCI, my lord. It was quite logic that, my lord, the FCI should continue with the proceedings, my lord. And also the as I have stated, my lord, this regulation 65 of the staff regulation of the FCI, my lord, and also the handbook for inquiry officers as stated in page 17, paragraph 34, my lord. The
Where did you
FCI,
get this handbook? Apart from statements, have you annexed this document?
I am not an annex, but it is a matter of record, my lord.
Whether these handbooks and these officers guidelines, these are certain things.
Mr. Chakrabarti, you keep on interfering. Your friend did not interfere you.
Not interfere.
Will hear you and reply. Don't worry.
So, my lord,
What is
regarding
this
the
handbook?
reasoning
No, tell me, what is this handbook? Why relying upon handbook?
No, I'm relying upon the handbook, that guidelines, my lord, because the FCI can initiate, after initiation of the proceeding, can proceed with the disciplinary proceeding, my lord. Only after the inquiry report, my lord, inquiry was completed, a letter was sent on 9/1/2019 to the Department of the Government of Arunachal Pradesh to take action as per the law, my lord. Because the penalty would have been a major penalty, so FCI could not have taken such decision, my lord. That's why it has been reported. The letter was sent, that impugn letter was sent, that is 9/1/2019, to the Chief Secretary, Government of Arunachal Pradesh, to take action as per the law, my lord.
You have filed this IA, there must be a source. Then it,
No, yes, my lord, that is the source, my lord. If need be, I will produce it, my lord.
Vigilance manual, CVC vigilance manual.
Yes, my lord. I will hand it over to the court master, my lord. It's your own, my lord. So, my lord, so far as reasoning of the inquiry,
What do you say about the inquiry report? It just
Yes,
suddenly
I'm-
says that charge is proved.
it is there, my lord. I would be relying on the BC Chaturvedi case, my
How do
lord.
you come to that conclusion suddenly like that?
That is there. Then
By the way, do you have that records
yes, my lord.
of the proceedings?
The proceedings were only food.
Only that much?
No, I
That cannot be the
I have
report.
all the exhibit lists, 1 to 9.
Exhibits?
Exhibit list, my lord. That the documents which were exhibited, my lord.
No, not only exhibit, the inquiry proceedings.
Yes, proceedings, my lord.
How was it done, the inquiry? How is it done?
How it was done, my
How
lord?
how does the inquiry officer proceed?
I have brought only the relevant part, my lord.
Like you have mentioned so many dates. On this date, this was fixed, she didn't come. On
yes,
this
ma'am.
date, she didn't come. This excuse, that email, this, that. So those things are recorded in the
Order sheet.
order sheets, order sheets.
Certain two, I think 2-3 orders are missing, my lord. If need be, I will produce it, my lord, on some other day, my lord.
Definitely, we would like to see that,
Yes, my lord, definitely.
how you have proceeded.
Yes, my lord.
Now, if a person fails to attend the proceeding on one occasion, 2, 3, 4 occasion, how do you go ahead? Till the last day, you'll ask him to come. And he will not come, you'll go ahead.
Actually, what from the one document, what I have seen that after each and every proceeding, my lord, a letter was sent to the petitioner, forwarding the gist of hearing while on that particular date and also the next date of hearing, my lord. After each and every date, my lord.
Any ex parte proceeding was drawn.
I have not found it, my lord.
If you don't come, we go ahead ex parte, something like that, nothing.
Yes, I have understood, my lord. On the next date, I will produce, my lord. That.
Okay, you go ahead. What else you want to submit?
My lord, I have not brought that decision, my lord. BC Chaturbedi case in 1995, 6 SSC 749, my lord.
No, what? Just tell me again. Citation?
1995, 6 SSC 749. It is BC Chaturvedi case, my lord. The Supreme Court has explained that the judicial review is directed towards the decision-making process and not ordinarily towards the correctness of the decision, as an appellate court would act.
Decision-making process. That is the well-settled principle.
Yes, ma'am.
Court will not substitute its own view.
Yes, my lord.
The decision
Yes,
process
yes,
is to be
ma'am.
looked
That-
into, not the decision itself. So you have to show that the process was correct.
Yes, ma'am.
Whatever process we did was by the book.
That was correct, ma'am. So, my lord, this much only. And regarding the charges are vague, that has not been pleaded by my learned friend, my lord, the petitioner. Nowhere I have found that he has pleaded that the charges were vague, my lord.
By the way, did he file representation against the inquiry report?
No, my lord.
He has not filed.
Not filed.
Instead, the petition was filed.
Yes, ma'am.
You have not filed, isn't it?
After the inquiry report and after 2-3 months, we have written to the department of government.
Because my lord, normally the representation is filed where the disciplinary authority is the same who will ultimately impose the penalty. Here, because of this deportation, my disciplinary authority at the end of the day is the state of Arunachal, not FCI.
Correct. But
So,
still, if you want, you can file your representation.
But before, because I was in a hurry, because I was under an impression or I was apprehending that a major penalty would be imposed upon me on the basis of this faulty inquiry report, and then an extreme penalty of something which is very serious or to the extent of dismissal from service would have been passed. Under that impression and apprehension, I approached this honorable.
Okay, what happened to the CBI inquiry?
It is still going on.
Still going on.
Still, charge sheet file.
Trial is going on.
Because your affidavit was filed in the year 2020.
My lord.
6 years back, saying that CBI case is pending.
Yes.
Now 6 years have gone, around 6 years, still pending.
My instruction,
So, my lord,
my lord,
witnesses are there, are lots of witnesses and lots of documents out there, my lord. Even we have initiated money shoot also, my lord. Yes, my lord. Another submission that he is my friend has submitted from his affidavit in reply. That is a query made by the legal by an advocate to its department that for filing a money suit, a specific amount has to be given. That was a communication between the advocate and the department, my lord. He cannot take advantage of that.
no. That is not a communication.
That was an observation made therein.
That is the communication between the departmental officer to the higher authorities.
After the receipt of the letter of the advocate.
Whatever it is not a privileged
Suit
communication.
is pending against the contractor, ma'am, for realization of the amount.
My instruction, my lord, only a handful of witnesses, maybe 3 or 4 witnesses have been examined in all these years. That too recently some 1 or 2 persons came. Otherwise, that CBI case finds mention in our writ petition also. And the present status which I could get is that some very few witnesses have been examined. And they are most of.
Okay, then you produce the records.
Ma'am.
When can you produce?
Around the last week of August, ma'am.
Why? We'll forget everything by then. Again, you'll have to start at the beginning.
On 28th, my lord, next Thursday.
20? Which tarikh?
No, 28 was too late. Produce before that.
No, he's saying 20th.
20.
20.
Oh, 20. 20 you can produce.
Or on 27, it will be convenient, ma'am.
No, 20.
My lord.
Today is what? Today's 30.
Today is 13.
So you're taking 1 week. The FCI office is here only. Why do you take such a long time?
Documents, my lord, because of this, some documents have been seized by the CBI, some documents are at headquarters like this, man.
Okay,
We will
whatever
try,
you
I will try my level best, man.
See, departmental proceeding, I don't think CBI will require that.
No, CBI,
You only say that this is a separate inquiry.
no, I'm talking about the documents which were exhibited, man. Certain documents were.
Our
seized.
documents exhibited, there's one thing, but I would like to see the process.
Yes, my lord, I will
How-
produce the proceeding, how it has
How you
proceeded.
have proceeded, day to day or
My lord,
week
my
to
lord.
week like that?
Yes, ma'am.
So Tuesday or Thursday?
Thursday.
Thursday. Let it be on 20th, my lord. 18th, my lord, I have some difficulties.
Proceed. Okay, right, hard in part. List again on 28/20/26. Mr. B.K. Singh and its standing counsel FCI shall produce the departmental inquiry records on that day. Mr. Adhikari, what will you submit?
My action will come around once the order of 24/5/2019 is vacated. Or lordship decides matter. Regard, my lord, the FCI completed the proceedings. They have, my lord, forwarded the proceedings of inquiry to us to take necessary action, my lord. So we will come into action, my lord, once this honorable court, my lord, takes a decision.
You have filed.
So we have filed our affidavit.
What have you stated in your affidavit?
Here, my lord, we have supported the case of the FCI.
We have supported.
Yes.
You staple this, okay?
So, my lord, my presence in the order may be required. Otherwise, there's a question of.
Why?
Instruction, my lord. Material instruction.
No. You forgot you are on live stream. Show them picture, I'm here.
Okay.
Anyway, before that, you heard Mr. S. Chakraborty, learned counsel for the petitioner. And Mr. V.K. Singh, learned standing counsel, FCI. And Mr. M.R. Adhikari, learned government advocate, state of Arunachal Pradesh. Hard in part, huh?
Obliged.
Your Honor, my senior counsel is not present. Kindly grant the
Yes, we'll adjourn it some other day.
Okay.
How many matters are remaining? Okay, we fix a date or give some time.
20 seconds. Of that.
Okay. You are there also in some matter? 25. We'll have a date.
4/9.